8th, 2013, 9:05. Again, item number 1, roll call for it. Could I, since I'm the only one up here, could you please state who you are for the record?
April Long, Secretary.
Koki Booth, Board Member.
Linda Zesiger, Treasurer.
Very next door.
Annie Curtis, Chief Inspector.
Monica Bradford, Administrative Assistant.
Gary Landry, Executive Director.
All right, and that's everyone. Okay, thank you very much. So item number 2 is comments by general public. Is there anybody in the general public that would like to make say something or have a comment at this moment in time?
Sir, here in Nevada, do you have any comments? It's open for public comment. No comment by public.
All right, seeing no comments, we'll move on to the next one. Consideration and approval of the agenda and its posting.
It has been posted in accordance with the Nevada open meeting law requirements.
Move to approve.
I'll second.
All right, agenda approved. All right, moving. Oh, that's right. Can I have a vote for approval of this agenda as written?
Aye.
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 Aye. Also, so let's see, did I hit the... All right. Okay, item number 4. Review changes created at the June 10th, 2013 law review subcommittee. I looked over all the changes and I thought you did a great job of laying it all out. I didn't see anything in here that I felt we need to change in any way, shape, or form. I do believe that some of the things that we did where we really kind of went over the top on separating everything out. Maybe the legislature will consolidate that, but I'll let that be their thing. At least they'll understand what we wanted to do and how we felt it needed to be. So is there any comment?
Harry, I'm having a hard time hearing you. Could you maybe move the mic closer or?
Thank you.
Yes, I'll speak up a little louder and move the mic closer. How's that?
Thank you.
No problem. Okay, so I've looked over the changes that we made that were put together by Mr. Landry, and I believe everything was in order. I don't believe there's anything that I looked at that I felt needed to be re-reviewed or redone. Is there anybody in Las Vegas down there, the 3 of you, that feel like, I know that Koki and April, you weren't here, so is there anything that you would like to add or comment on these proposed changes that we did last meeting?
Not at this time, Perry.
For me. I'll comment as we go along, Perry.
I'm fine with this so far.
Okay. April, we're going to just be moving on here shortly for this, so if there's anything in here, shall we wait for you to... This agenda item is going to be over with here momentarily here, because we're not going to go through all of this, because we did this all last meeting.
We're ready to move forward, Perry.
Okay, sounds good. All right, so seeing that there's nobody wants to make any changes or comments, I don't know if we have to approve this or if it's just...
Gary Landry, Executive Director. My suggestion would be to take a vote so that it's approved as written, and then if further changes need to be done at a later meeting, they can be done, but at least it's approved as written, and it'll be a part of the entire package, as you had indicated, Gary, at the last meeting, part of an overall package. It'll go to the board as one piece of legislation.
All right, so can I get somebody to make a motion, please?
A quick comment, Perry. April Long, Secretary. Can we be adding things as we go along as the meetings progress, or are you, as I wasn't here for the meeting last time, or is there going to be kind of a stay on adding new things as we progress in these meetings?
You may add any subject or any change to any of the NRSs that you wish that we don't currently have on our list.
Okay.
And we will agenda them and put them up for discussion.
Perfect.
At any time, you can email me and say, I'd like to add this, and I will put it on a future agenda.
Thank you very much. I apologize for missing the last meeting. I had jury duty, and this all looks really good. I like the agenda. I think this looks fabulous so far.
Thank you.
I move to approve.
I'll second.
Can I have a vote? Aye.
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 Okay, unanimous. So approved. Yeah. Okay, next on the agenda, number 5, review and possibly formulate revisions for submission to the 2015 legislature to NRS 644.190, unlawful practices without license exceptions. Every weekend in Nevada, there are hundreds of both licensed and unlicensed persons working in hotels and wedding chapels, performing cosmetological services for wedding parties. This has been an ongoing issue and has become unenforceable and needs to be addressed. Other laws that may need to be reviewed or revised under this topic are NRS 644.460 exemptions, NRS 644.475 styling of purposes restrictions, NRS 644.490 additional penalties for person who engages in certain conduct without license, authority of the board to issue citations and orders to cease and desist, administrative fines, appeals. In addition, an administrative code may need to be revised. NAC 644380, place of practice, licensed cosmetological establishment exception. All right. So the staff has put together their comments. Does anybody in the audience need a copy of that, or would you like a copy?
Does anybody here in the audience need a copy of what we're saying?
All right.
They have the agenda.
Good morning, Ms. Penelope.
Perry,
Yes.
I just was able to read today the article that was sent out by the staff, the recommendations by the
Yes.
staff. And I think the idea of regulating the advertising and execution of these practices, which would help the following manner, and then the guests would be able to if we were in contact with the hotels, and let them know what the laws are, and it would also bring business to them, to the hotel beauty salons, but also only licensed cosmetologists that would be able to go to the rooms.
Okay. I'd like to take one moment and let the record reflect that Ms. Jeanette Rinaldi has arrived and
Hi, Jeanette.
now part of this.
Hi guys.
You need to use your mic to speak to them.
Hi guys.
I can't understand him.
Thank you. For the third time. Hi guys.
Okay. All right. So, Linda, you are in agreement with the staff recommendations. Is that what I'm hearing you say?
I'm sorry, I couldn't understand that.
So you're in agreement with the staff recommendations. Is that what I'm hearing you say?
Yes, I am. Because working in a hotel and casino, I know how many wedding parties that there are, even though we do not have a wedding chapel, and the people from outside are coming into the salon, or not into the salon, but into the hotel. Security lets them up because they call up there and say, oh yes, those are my friends, let them up there. And they're going up there and they're making all the extra money, and I'm sure that a lot of them do not have licenses. But you can tell that from sometimes you're advertising on the Craigslist and so forth. So I think it's a good idea to be able to get to the hotels and let them know what's going on, because it's taking business from them too.
All right.
And I have a little bit different thought on it. I think as a public member, I think that this is going on out there, and I don't think it's our responsibility is to tell the casinos who they can allow in and who they can't. I think what we need to do is make sure that it is a licensed operator going, not make sure, but that a licensed operator is going in there and they're doing it properly and there's a standard for that. But I don't think educating getting involved with the hotels, I don't think that's our business necessarily. That's just my opinion.
Thank you, Koki. April?
I think as long as you're licensed, you should be allowed to be able to perform services in the rooms of a desired client. Especially I've had clients of the late who have a disability and cannot, get into not only between a hotel but their homes and whatnot. And I feel very torn. I've abided by the law and have them brought in, and I assist as best as I can. But something like this to pass would be fabulous to bring this to fruition. I think that this is a great idea. I think it's long overdue, and not only for hotels, but be able to license cosmetologists go into any facility outside a salon and be able to perform a service for somebody who needs it in a safe, legal way.
And I have one more thing, I'm sorry, that I'd like to say here, Perry, was the way we're getting around that law right now, or they're getting around, as long as they carry a camera with them and they're doing photography work, then they can prep the client. So I think that we need to bring this out of the closet, make it a legal profession, and allow the professionals that do a good job continue this business and make it grow and enhance it. I think when you're underground kind of with it, with this scenario of just carrying a camera with you, that a lot of the professionals that do a good job can't really get out there and express properly what they do. That makes sense.
Annie Curtis, I'd like to make a statement.
One moment, April.
I'm just challenged on how to be regulating these people. How do you make sure that the professionals are professional?
Just like you do in a salon.
Right. Well, it's a little more difficult. April, you had a comment? April?
No, it was Annie.
I'd like to make a statement. Can you hear me?
Yes,
Hello?
I can hear you. Please go.
Okay. I'd like to kind of address that the public is also in the hotel. And I think our job as the Cosmetology Board is for the protection of the public wherever they are in the state of Nevada. And I think that if we are not trying to tell people what to do, we're trying to expand the ability of protection for the public. So I think that by expanding this law to where it will have some controls as to who is actually working on the public would be helpful to the hotel as well as to the industry, and keep it in a professional manner. So I think this is where we should be centering our attention on the protection of the public wherever they are. And that would mean that we would get in touch with the hotels to make a better communication as to how we want to deliver our service. Thank you.
Thank you.
Perry, I also know that with your local wedding chapels, almost all of them have out-call hairstylists that they call in. And I have been told, because we've corrected a few things, where these people did not have licenses, they couldn't possibly have a license and done the work they did. And that means applying makeup and doing hair. So we've had phone calls where I've had to go down and open the shop up on a Sunday because some bride's hysterical in the hotel. They're staying in our hotel, but they've had the work done in their rooms. So it's just, it happens out there. And there are people that, because their mother or somebody told them they're a great hairstylist, they don't have licenses and they still go out there and do hair and do makeup. So I think you should have more control. We need more control over it. And it's going to be hard to control, but if we set the laws in place, at least we have something set that we can go by.
And I'd like to say, I agree with that. I agree with what Annie's saying. My whole thing is I think that we need to set down what the cosmetologist can do, and that the things have to be disposable that she's using, and set that into law. But as far as educating the casinos, I think that's a good tool. But really, I think it really goes to the licensing portion of it, so that when somebody does have a bad product, they have a way to, they have somewhere to go to the Cosmetology Board to file a complaint against that hairdresser. I don't know how you're going to enforce, just like we can't enforce the people that are illegal, that don't have that aren't resident or aren't U.S. citizens. I don't know. It's hard to enforce that unless somebody turns them in. But if we had the law in place, then we could at least do something when somebody did file a complaint against that person, that we could take care of it. So that, I agree with that 100%. I just feel that the hotel, that's the issue that really isn't ours to deal with. We can educate them in the beginning or whatnot, but they don't even have a lot of control, I think, sometimes of who's going in and out of a room. So that's my whole point of making a law, that we have no control over it. It doesn't make any sense to make a law that who's going into a casino we're going to be monitoring, because we can't.
Thank you, Koki. Jeanette?
Yeah, I agree. I don't see how we're going to regulate that. I mean, if somebody asks me to go do a wedding party, take my team up to a hotel, I don't check in at the front desk usually. I ask them what room they're in, and we walk right up. That's how it used to be done. But until I knew that there was these laws, and of course had to educate myself. So this is a conundrum, because if I was in a hotel like you are, Linda, I would be very put out by people being able to come up and take business away from me. But I think that there's the way to look at it is by stating professional people do it in professional places, and maybe kind of going that way with it. And then if you're caught going out of your professional scope of practice, like any other professional practice, then that's when we ding you. I think to stand firm in what we do is more important than creating all these laws trying to make everybody happy. Just, this is the way it is. If we catch you, we're going to find you.
Okay, so I'd like to narrow this down a little bit. Jerry did a great job of providing us a way to do that, in that he gave us some specific staff recommendations. So I want to take up his recommendations one at a time so we can discuss those, because our comments are kind of all over the board for all four of these recommendations. So we're going to take up the very first one: require all advertisement for any cosmetology services to list the name and license number of the person advertising the services, similar to general contractor requirements. Currently, we have a Craigslist watch of sorts, right? That is trying to cut down on any advertising by people who are advertising for services or for clients, right? Okay. And that's ongoing and effective at the moment, correct?
It is ongoing, as effective as far as we can. The thing that we're hampered by, following current law, we only will point out those ads that specifically say that they will go to a room or to a non-cosmetological establishment.
Gary, we can't hear you.
Is this better?
Yeah. Yes.
Okay. Sorry, I apologize. I'll start over. The Craigslist project that we're doing now, we actually comb through Craigslist, find those people who are advertising that they're performing services outside of a cosmetological establishment, which is against the law. We report that to legal counsel at Craigslist, and they remove them immediately. So that's worked out very well. The problem is Jeff Green spoke with me and gave me a list of 22 websites that we've been monitoring in the past that may or may not have legal counsel, and may or may not cooperate with us, that are advertising a full assortment of wedding services. They're wedding-specific websites, so hair and makeup, all of these things being performed in the rooms. We're taking a look at those and trying to contact if they have legal counsel or not. The problem that we face is that because there's not a blanket requirement to have a license number, I think the staff feels that the public is not protected. Just as Linda said, some unlicensed person performs a service, botches the job, and there's absolutely no way typically that we can find them or bring charges against them. They're not part of our jurisdiction because they're unlicensed. And if we do actually find them, we can turn it over to the Attorney General's office to prosecute. But that's a very long and painful process. The reason staff came up with this recommendation is we would then know every person who doesn't put their license on an ad can be taken down immediately. And that becomes a much faster, more effective process. And if someone has services, they'll at least know who that licensed cosmetologist is. So if it is done in an unsanitary condition, or if it's done improperly, they have someone that they can complain to, namely the board.
I think that's a really clever and good way to approach this, because to me, this is a consumer-driven problem, and it's not so much a hairdresser-driven problem. The consumers want hairdressers to go to their location and to do this service. And I know most of the hairdressers I know, they would much rather do their services in a salon because it's just so much more convenient and it's just way better. But consumers are driving this. And I think it's completely very, very difficult to regulate and highly costly. So I think that this would be a very good way of approaching at least the initial contact between the stylist and the consumer. So I'm in agreement with this one.
I have a question, Perry.
Any other comment? Yes, Kobe.
On this one here, where they have to, if I'm understanding you right, we're talking about putting the license on their license number on their advertising. Is that correct? Is that what we're talking about?
That is correct. If they were to put an ad on Craigslist, they would need to have their license number there,
So
so we know that they are a licensed person.
So across the board, we're going to require all advertising to have the license number in it, or are we just talking about wedding planners? Because if that's the case, then I have a problem. I think anybody that advertises should have the head salon's license number in there, or why would we just apply this to people that are going into doing weddings? I think it should be across the board. Everybody should put their license out there if they're advertising.
And what would it do to stop somebody who's not licensed from copying and pasting somebody else's license on there? Because the client's not going to look at it. The client's not going to care. She's in the middle of a wedding and somebody walks in to do her hair and makeup. She's excited. She's not thinking about a license. But what's going to stop somebody who isn't licensed for misusing somebody else's license number?
Nothing.
Or possibly
have.
I'm sorry, Perry.
One second.
So
to Koki, to address your comment, the way this is written, it would say it's require all advertising for any cosmetology services. So yes, this would be an across-the-board advertisement. If somebody puts an ad in a newspaper, they would have to have their establishment license or their personal license on that ad somewhere, similar to what contractors do, because when they advertise, they have to put their license as well, because they have the same issue we do. They have a whole lot of people out there doing unlicensed work.
And I think that's a good idea, because then you could go to the state agency and look it up, that person's actually licensed, so you could do that on.
Having their
There's a
license.
certain amount of trust factor that we have to have. We can't regulate every single little thing.
It's to start educating the public, though. That's one good thing about it, so that they'll start noticing that, hey, these people have their license. I notice when I see a contractor's license when they're advertising versus somebody that's not.
Your license your license is public knowledge because it's right there on the wall. So the numbers are right there. So what's the difference if you put it in advertising?
I don't think it matters if you put it in advertising, but there are going to be those.
One at a time.
And let me call on you, and then you have time to speak.
Okay.
So we don't talk all over each other, please.
I mean, I don't think it's a big deal because anybody can go to the cosmetology website and look up somebody's license and name and see if they're licensed or not, and their number is public knowledge. But I mean, there are those people that will take advantage just to, copy somebody's license down and use it in an advertisement. That Craigslist ad now gets kind of looked over because they're using somebody else's number. So that's just a concern that maybe if they registered with the board as wanting to be a mobile stylist, that we give them a registration number to use versus a license.
Miss Annie has her hand up also.
Yes,
Addressing the concerns of April, consumers are a little bit more savvy than you expect. Once you start a process like this, you would try to educate the consumer to make sure that they can get in touch with the board. But you also would educate the consumer to look for identification from that person to go along with the name and go along with the number.
Absolutely.
So you would have some balances and checks in there. You're not just going to put numbers up there with no ability for the consumer to be able to check those.
To cross-check.
And they can call the office to see if the name goes with it. So there are ways to remedy that situation if this was to be in effect. So
even if there was specific verbiage that needed to be used by the stylist on these ads.
It would kind of be like any of the contractors that you deal with numbers. If you're going to have someone work on your home, you're not going to let the contractor come there without you checking out something.
Absolutely.
So I feel that that would work for us in that manner.
And I agree
So
with
I
that.
have a question. I have a question of the staff. How many complaints do we get regarding wedding services given to the board?
What's the question?
Gary Landry, Executive Director, you're talking about actually presenting to the board, or just did we get in the
That you get, how many times
do we
per
get?
year does somebody call up and say, I had bad service?
I don't have that number specifically, but I can get that. I can get that number as well, all calls and complaints.
Perry, it's very difficult to hear you. You got to speak
Sir?
a little louder.
What I was asking is, how many complaints do we actually get? People calling in and
About
saying, I had a
weddings.
wedding service
Wedding
and
service.
it didn't go well.
We do get calls wanting to know if the licensee is licensed. We check it. We ask for description sometime and pull the file and give a description, or they give us a description, and if it's close to it. But most of the time they check it with licenses for the person in the state and those kinds of things. But we do get the calls. Not a lot, but we do get
How often
calls.
do we get a call that says something went wrong by a consumer? They want to complain against a hairdresser
We get consumer calls all the time.
regarding
Complaining
wedding
about services that have been rendered.
specifically for the weddings.
Pardon?
Specifically to the weddings.
No. We get those calls about Craigslist all the time.
Right, but I'm trying to determine how big of a problem, how many times does a consumer actually try to complain to us about a service being performed outside of a cosmetological establishment in a hotel?
We usually get the calls from the licensees complaining about the people working unlicensed. We don't get it from the consumers.
Thank you.
You know what, Perry, if I can speak, is it okay if I speak?
Yeah. Yes,
I think the biggest thing with this is something that, being that we live in Las Vegas and Reno, where you do have the casinos, you do have the weddings, it's a draw here to do something like that, that we need to come up with a way to allow the public to be able to have what they want, because it is consumer driven, but basically just to put in our law book, these are the standards that you must, so that we can go after them if they do harm to the person. And I think right now we're just running everybody underground. So I think that for us, I have no problem with that, putting the license number on there and coming up with a set of rules that if they have to come before us, that we can manage. Because if they don't come before us, then there's no reason. But that's my feeling, is that we should just deal with those two issues. Let all the casinos know that they have this avenue and go from there. But that's what I think we should really be zeroing in on.
Right. Right now, we're trying to zero in on whether or not we should require the advertisement to include a license number.
Then I would move to approve that.
Excellent. And Mr. Landry, if a person were to call in and they say that Ms. Smith performed a service on me and I was dissatisfied with it and her license number is this, we would then take that complaint, correct?
That's correct. We will take a complaint whether they have a license number or not. Without a license number, it's nearly impossible for us to track the person down.
Right, so what we could then inform that customer of is that if there's a license number, we will move to investigate. If we don't have a license number, they're basically SOL.
That is correct.
And so over time, that will actually, I believe, become something that consumers will understand that, and I think they'll get that. So I think this is really good. So the next thing I have a question of.
Perry, I have a motion on the table to approve the licensing. Are we going to do that?
I didn't call for a motion yet, and but I will in just a moment. Hang on one second. Mr. Landry, what section of the NRS would this one recommendation be put into? Did you look that up?
I did not look that up for this meeting, but I do have a proposal for a future meeting to consolidate all advertising requirements, because it falls in two different sections of NRS, and we'd like to consolidate that down into one specific section that covers all of advertising. Because it not only will it require the license, but it doesn't allow you to advertise for non-cosmetological services within the cosmetology ad.
And that's going to be part of our next board meeting? Or what is it? What's your timeline on that?
I just submitted the wording and the suggestion to you, and it'll be on one of the law subcommittee future meetings. That the advertising changes to the NRS.
That's correct, yeah. See, I'm getting all confused with that stuff. All right, so yes. So I would suggest then that this particular recommendation, we move it to the discussion on advertising, and I will put that on next law committee's meeting next month. So this particular section right here, specifically related to weddings, will be moved to the general discussion on advertising that we will be having next time.
Perry, it's really hard to hear you here. So we're not going to discuss this anymore, the licensing portion of it?
No, we're not going to discuss it. The requirement to put a license number on an advertisement, we're going to further discuss this at the next meeting, because at the next meeting we're going to be discussing advertising in general for hairdressers and being able to advertise for non-cosmetological services within a cosmetological establishment, as well as this item right here. And I think that this item in particular, even though we're talking about the wedding stuff, I think this item in particular would do well to be discussed along with all the other advertising. So we're going to just move this along to the next meeting where we can further discuss this specific recommendation.
So we're going to table advertising and move it to next month's meeting. That's correct. We're not going to discuss advertising anymore.
Correct. Because the discussion will be broader and more general and more appropriate to the entire subject matter. Is that okay with everybody else?
Yes.
Yes.
All right, so be it. So now we're going to take up staff recommendation number 2. Require all licensees who wish to be authorized to practice wedding services outside a cosmetological establishment to take a class administered by the Nevada State Board of Cosmetology, pass a written exam, and receive a certification to practice specific listed wedding services outside of a cosmetological establishment.
Perry, I disagree with this one. I think if you're a licensed cosmetologist and you know how to do it, I mean, you've gone to school, you've got your license, you've been educated in this field. I think what we need to do is just set the guidelines up of what they can do or can't do as a cosmetologist. I find it, I don't know why they'd be having to go, I don't know why they'd have to go to school, so I'd like to hear staff's reasoning why they felt they would have to go to school for more education.
I'd be interested in that. Mr. Landry, could you?
And if this came from a suggestion of the schools?
This came directly from the inspection staff, and the reason why they did that is when you enter a hotel room of unknown cleanliness, of unknown persons, and unknown conditions, if you're not trained specifically on what needs to be done, inspection staff didn't feel that every cosmetologist would be properly trained to take and clean off the surfaces, put down a non-porous board or drape something on the floor, and not transmit problems from one room to another. Because staff could envision someone would specialize in this particular practice and would be going from hotel room to hotel room, bringing with them things that should never have been brought with them. So that was the reasoning behind it. It came strictly from the inspection staff. We had a meeting and we discussed what are the ways that we could protect the public and still allow practice outside of the cosmetological establishments. The way staff envisioned it is if there was some specialty training, we said specialty training, but we thought that we could put together a few specific items that it's really an awareness, letting them know when you walk in, these are the steps that you do so that there's some uniformity to it. It wouldn't be going back to school taking hours of class. It's really an instructional class so that someone could specialize in freelance or mobile cosmetology services.
Now, would this take place? Would this take place at a school, or is this a class that the board would facilitate?
We envisioned it being facilitated by the board at the board office, either in Reno or in Las Vegas. The outlying areas, we don't think this is big a problem. We don't see the same amount of wedding services being performed outside in the smaller casinos outside the two major metro areas. I'm sure it is, but it's not something we thought we would have to address at this point. Immediately, the bigger problems and concerns were in Las Vegas and Reno.
I have a question, Gary. Could this be done on a video where somebody could go and take a test like they do the health test right now instead of having to come to the board to take a test? My concern about this is that you don't want to stop someone from doing what they do, and that's a cosmetologist doing what they do, by having them have to travel into either Reno or to Las Vegas to take that test. Is this something that could be done and we can set it up like we do the health test?
Or a webinar?
I think anything's a possibility. I'd have to, because I'm not a cosmetologist, I don't know to what extent the video training could be effective and to make sure everyone knows what they're doing. Right now, this is all unregulated. It's going on every day. So staff felt that anything we did would be an improvement. So up to board discretion on what level to have this done. But staff is open to any type of educational requirements that would better and enhance the public safety.
Jeanette?
I'm really not happy at all with this whole conversation. I mean, we were just discussing kiosks, and we have to have certain height of walls, and it has to be 100 feet from the bathroom, and it has to be right. And now you're saying, you know what? If you have a license, you can practice anywhere. So what is it, girls? Are we going to say, hey, who needs a building? We could just practice wherever we want. Or we're going to say, you know what? You're a professional. Practice in your building. And the people that want to practice outside their scope of practice, are not licensed, good luck. If they hurt you, we're not regulating those people. We regulate the people that we regulate. We watch over them, we make sure that the general public is safe, and that's what we do. Now, I just don't agree at all that we should just say, hey, here's to you. If you have a license, go wherever you want, practice wherever you want. We're not going to watch your walls, your bathrooms, your amount of water you have, clean, dirty. I mean, it's just, this is completely ludicrous to even be considering this. If they want to practice outside the scope, let them practice. If they get caught, we fine them. And if they're not practicing with a license, then the general public will be educated that the only people that we're going to protect you from are the people that are licensed. They'll have a number on their advertisement, and that's it. I think this is a Pandora's box. I think it's a big mistake.
I don't know that if I was going to be doing hair in a motel room because my client's getting married and she wants me to come up to her hotel room, whether or not I'd go through the administrative requirements voluntarily to do this. And so I'm in disagreement with this recommendation as well.
I would like to say one thing here, like with the kiosks, we don't make them take it. I think right now we're talking about the educational piece. We don't make the kiosk people take a class on because they're not the same as a beauty salon. what I was simply trying to say is that I think that when you open, if we're going to oversee these hairdressers, which I think we should, that we have a set of rules that we set up for them that they have to do. And Annie just mentioned some of those rules, and she'd like to speak after me. But I think that we should make those rules up, make them a law that people have to abide by. You can't even force people in a salon to do the right thing, but then the public would have a recourse if this hairdresser went in there and didn't do the things that we required. My concern about having an educational piece where they have to go into the board, that someone that maybe lives on the outskirts, it's harder for them. And I think it should be something that anybody could do. So by going online, taking the class online, passing the test, that person would be educated. So this is a Pandora's box that's already open because it's going on today. So now I'm going to turn it over to Miss Annie because she'd like to speak.
Okay, speaking on that issue, I think it would be possible to do it with video. What you want to do is similar to what you do in testing. If a person's going to work outside the salon, have them know to wipe down the chair, make sure they have clean coverings and things like that to put their instruments on, and check for the water and those kinds of things within that particular area. It's similar to when they're doing donated services. We don't have them take a test, but we do have them get in touch and get approval from the board. And then they have to tell us how they plan to maintain sanitation. Usually they tell us that they're going to use disposables and they're going to use barbicide or this or the sprays and those kind of things for the clippers. So we just want to have some means of how you plan to protect the public. Since this is something new, we feel that you need to educate the licensees to another step. Not that they don't know what to do. If we're going to put something new in place, we need to say, this is what we want you to do, and we'd like you to do it in this manner for the safety of the public. This is what that was about. Thank you.
All right, so my comment on this, I'd like to comment here. We already have those regulations in place. People know, hairdressers know, they're not supposed to go outside of the cosmetological establishment and do hair. They do so knowing full well that they're in violation. And I think that if you were to license them in any way, shape, or form, it pretty much gives them a license to an acknowledgement that says we tolerate that. And I think we don't. And I think the laws to protect the public exist because in that existing law is don't do hair outside of a cosmetological establishment.
But Terry, that's not true. They can go do it if they have a camera with them and they're also a photographer. That's where the real problem comes in.
Yeah, none of the hairdressers that I've ever seen do hair outside of at wedding services ever have a camera with them. Well, they just go full no. They just walk in and they are the hairdresser and the makeup artist, and that's it. They do it without sanction, and they know full well that that's what they're doing. And I think that we have laws in place that say they shouldn't do it, and if they mess up, well, then they receive the penalties that we already have in existence for that. So I don't think we should give them any license to do this, because we're already doing that. I think that the concept of leveling the playing field a little bit by making sure that the advertisements are good is plenty good for prevention. But by and large, being that we don't get hundreds of complaints per year that somebody was in a hotel room and doing something, and that the majority of the complaints are from the hairdressers complaining that they didn't have an opportunity. Well, I'm sorry, but this is you make it or you don't. You advertise well, you do good hair, you do whatever it is. It's competitive out there, and I don't know that I'm willing to accept this recommendation, is all I'm saying. So
I just think
need a motion.
in Las Vegas, it is definitely a profession here, and I can give you names, a couple people that do carry their cameras with them because they know that's how it keeps them legal because they've been caught before. So, and probably if you walked into the Las Vegas salon here, they'd tell you that's how it's done. So I just think for the public safety that, and that's where I'm really going with it, is that we need to get it out in the open instead of keeping it underground, because it is a profession here in Las Vegas. Maybe not in Reno, but it is here. And I think Linda can probably attest to it, because you do hear about the complaints from the bad hairdressers. And they do, and they'll go and tell somebody about it, but not necessarily know where to file. The public doesn't sometimes necessarily know where to file. But I think instead of just saying, okay, this was wrong, you can't do it, but if you have a camera, you can do it. So anybody that gets caught one time or gets punished, they're going to carry the camera with them next time. I just think we need to bring it out into the open and keep it, instead of keeping it underground, for the general public.
I want to address that too, Koki. If they're carrying a camera, it's not because they're carrying a camera. They're supposed to be licensed photographers. They're supposed to have a business doing that.
And doing hair at no charge.
So if they come before us and they had a camera, I'm still going to ding them because they are knowingly doing this. I mean, it's a minimal requirement, for heaven's sakes. Work in a clean environment, bring the people to you. Consumer driven. If I go to a person's hotel, can you please trim my bangs? Because that's what the customer wants. Oh, well, you know what? I just want some highlights. Do you have any bleach? I know you only have an hour. Can we maybe wrap a perm? I mean, what are we doing? We're decimating the whole, system here. Yes, they're doing it legally, but let the buyer beware. Let's put a license on them. That way we can regulate the people we regulate, and if people want to go out there and do it on their own terms, and they get hurt, well, then you should have got a licensed contractor. Sorry. That's what we can do. That's how we can protect ourselves. That's how we can protect the public. That's a win-win. But if you open this up, I'm telling you, it's going to be a Pandora's box. Because I, as a hairdresser, why would I have a building? I'll just go do hair all over town. No problem.
Let me ask
I'm telling
you,
that's what most people will do, and it will not be able to be regulated.
let me ask you this question, Jeanette. So if I'm a hairdresser and I go and I perform,
One moment, please. Mr. Landry had a comment.
Okay.
Yeah, one of the comments I wanted to make, we did recognize that, this whole Pandora's box, we were doing this in response to, the what's already existing out there. We specifically put wedding services as an exception, that we were not opening this up to mobile, just going out and freelancing anywhere you want, but we're well aware that just as they're using, the camera, the camera parity, or the camera front, they could say from any service they're doing in anyone's home at any time, as long as that person agreed it was for a wedding, they could do it. So you are right, Ms. Benaldi, it does open up where the only thing that you would have to do is claim that it was for a wedding, whether it's factual or not. As long as you're a client and you both agree that these were for wedding services, that is another loophole. So I just wanted to make that clear. But that's why we specifically held it to wedding services. That it was to address that exception only, because this is a part of the exceptions part, not a part of the general practice. This is exceptions. One of the exceptions that would be listed, under staff recommendations would be wedding services. But it does open up the ability for a licensee to advertise wedding services in any location.
Thank you. Okay, Koki?
my thing was, so the hairdresser goes and gets her license. It's like $100 in Boulder City to get a business license. And they go to do hair as a photographer. Which license are you going after at that point if somebody complains about that? Which license number do they post? The photography license or the cosmetology license? Because if they went in as a licensed photographer, then can we go after them as a cosmetologist? So that's one of the scenarios that I see that I'd like to see change, that we could go after them as a cosmetologist because we would approve their services so that we could. That's just kind of where I'm coming from.
License. If they hold a cosmetology license, regardless of what they're claiming, they still hold a license, we still could go after them. Especially if there's a complaint about hair.
I have an issue with this whole concept of going after them. I understand we're here to protect the public, and the laws that we currently have do protect the public in that we don't want them going into hotel rooms to do this. But I think that there's a bit of a blind eye that we need to turn to this a bit, because if a client complains that they had a bad issue, it's like we take the complaint and say, well, that's very nice, but you should have hired a licensed hairdresser and been in a salon, because that's what our laws regulate that you have to do. And it is a buyer beware scenario here. And I don't think we should give anybody any concept of an idea that they can get any kind of a license to do hair outside of a cosmetological establishment. I don't think that the legislature would go for it in any way, shape, or form. So that's my opinion. I'll take a motion on this particular recommendation if anybody wants to make a motion.
I have a quick comment. I think that if you told the licensed cosmetologist they had to take another test or some other kind of thing, they're going to say, and that you're slapping something else on me, they're going to laugh and do hair at a hotel anyway. I mean, the current ones. I think a good way to do this is to, down the line, if you really wanted to implement something, is put it into the testing. But I think that's a whole other can of worms, and then deal with the licensees that are already licensed, kind of on the back end. But you do this, do the ones that are up and coming and put that education into the hands of the schools and integrate that into testing at the time of licensure. That's just my comment.
And I'm going to make a motion that we move this discussion over, like we're doing the advertising, but move it over to the general board to maybe get the whole board's feeling on it. I personally would like to make a motion that we have education on this if we're going to go after the licensing of it. I'd like to see us also educate these people. I think that's an important piece, and I don't believe you're going to get rid of it. So my motion would be to have an educational tool and test, like we do with the MRSA test. I'd like to see something like that, so I'd like to make a motion that we do have an educational tool and testing. If I could get somebody to second that. Nobody wants to second it.
Nobody wants to second it? Motion fails. All right, so since we really can't agree, let's just move on and say that this particular item, we don't have any agreement here to create a motion on this. So let's move to the third item and talk about it. Require the Nevada State Board of Cosmetology to publish names, license numbers, and hotels or resorts where they are authorized to practice of those individuals who are certified to perform specific cosmetology wedding services outside of cosmetological establishment. I think that this is somewhat moot since we can't agree to give them a specific cosmetology wedding services certificate of any kind. So this isn't very feasible. We could talk about whether or not we want does anybody want to talk about anything on this? I think this is kind of moot because we're not going to be issuing any kind of cosmetological certificate or license to someone outside of their current thing.
I think maybe let's see where the Craigslist filtering goes and readdress this, just put it on the back burner. I think it's a very interesting topic. I think that it's worth readdressing down the line and kind of see where the Craigslist thing goes and maybe encourage putting the license number on there and see how that works. But I think that this is a huge, huge topic. I think it's interesting, and I think that it should be readdressed down the line.
Okay. Anybody else? Comments from the public? Okay. Moving on to the next one. Require licensees to provide the Nevada State Board of Cosmetology written authorization for approval by the hotel or resort where they wish to practice cosmetology services.
That's moot. That's a non-issue if you're not going to deal with that.
It's a non-issue as well. All right, so those are non-issues. So now what I want to do is bring up anything that you may have that you think, outside of the staff recommendations, what is it that you think we should be doing to address, legalize, sanction wedding services outside of the cosmetological establishment?
I know that I think that even just checking in with your wedding planners at the hotel, I know probably 70% of the wedding, staff that does weddings in hotels in Las Vegas, and I work with them, encouraging them to find transportation to the salon. Rather than me coming to them, I'm very uncomfortable doing that now that I had found out about the law when I found out about the law, back when. And I think just checking in with them, letting them know your availability, letting them know where you are, I think is huge. Just making contacts and making conversation and letting them know, giving them the information, giving them a law book, checking in with them, letting them know that, what laws are out there governing being outside the realm of a salon, because a lot of the times they'll go to those and say, hey, can someone come to my room? And having somebody knowledgeable there saying, no, it's not legal for a licensed cosmetologist to come to your room, but we could try to provide transportation services or put into their wedding packages or whatnot. Because I know I have packages in my studio that include, trial updos, trial makeup, this and that could all be stipulated, like I said, going back into, a wedding service. Was it for a wedding? Well, it was a trial updo, and she had, special occasion or whatnot, so anybody can say it's for a wedding to show up. But I think making those contacts and making the public aware is number one, especially those who are dealing with weddings every single day, even the chapels, outside the hotels. I think bringing that awareness there would be an important facet.
And I have one staff question, if I can ask Miss Annie, because maybe I'm wrong. If somebody comes before the board and they have a licensed photographer and they're not happy with the hair services, can you go after them for the hair services even though the hairdresser was licensed?
That would be out of our jurisdiction because they are exempt. If they are employed by the photographer or the photographer, they're exempt from us.
Okay. Oh, so they can be employed by a
They need to be
Okay.
They need to be employed.
Okay, so they can go do that anyways. Okay, thank you.
Yeah, so just, Koki, to be clear, that regulation requires that a person be a photographer and that all the hair services are done at no charge. And that it isn't, and if somebody doesn't like the hair services, well, it's the photographer that has to like it or dislike it. And because that's how that's supposed to go as far as that law is concerned.
I'd like to talk about that for a minute. So what you're saying is, if somebody has a photography studio,
Yes.
they cannot hire a hairdresser to
Sure.
work at their place and do hair, like, I don't know, in a forest somewhere.
I'm assuming that what that means is that the photographer builds that price into their service fee. So when the photographer bills the client has that, gets a bill from the photographer and does not get a bill from the hairdresser. And the photographer then pays the hairdresser for the service because the photographer is hiring the hairdresser. The client is not hiring the hairdresser.
Okay. Well, that's interesting.
Perry?
That's how that works, to the best of my knowledge, correct?
Perry,
That is correct.
this
Yes.
is Linda.
Linda?
I would like to explain in our hotel, when someone calls for salon services for their wedding, and they want us to go to their room, I explain to them very nicely what the law is, and I also explain to them how much easier it is to have it done in the salon. So I really have never had problems with it, but at the hotel, anytime any of my licenses are due, I get calls from the executive offices wanting copies of all my licenses, whether it's state, county, whatever it is. So don't think that the hotels do not know who's licensed and who isn't licensed, because I just had a call last week asking me if I had my new salon license. And I said, no, that I had not received it yet, but I had paid it. And so as soon as I get it, I have to send them a copy of it. So it's also, that's why I'm thinking that the hotels will cooperate with you. That's all.
Thank you. So what we're trying to do here is we're trying to create some NRSs, some suggested NRS changes. So the only way that we can do this, the way, in my opinion, is if we went to NRS 644.190, unlawful practices without license exceptions. That would be the only place I would think that we could place something that would allow wedding services, much like this photographer thing.
I don't agree with the photographer thing either, because if somebody gets their ear burned by a curling iron, are we not responsible for that licensee?
No,
All of a sudden, not our licensee anymore?
they are not our licensee at that point in time. They are completely exempt from the rules that we have.
Then they should, in the future, be allowed to advertise with a commercial license, using our licensing system. I think that has to be part of that exception. So if they're working under somebody else, just like med spas, we have a...
Let me read you exactly what it says here. This is under NRS 644.190, subsection 3, item D. The rendering of cosmetological services by a person who is licensed in accordance with the provisions of this chapter, if those services are rendered in connection with photographic services provided by a photographer. That's what the exemption states.
So the hairdresser can't be the photographer unless they're duly licensed.
Correct. And they would be then charging the client for the photography, and the hair is incidental to that.
So I would think we would regulate it as people.
Mr. Landry?
Just to clarify on the quote licensing of a photographer, it's a business license only. There's not a board of photography. So if you go and pay $200 to get a license, a business license, and you claim your service is photography, you've satisfied all conditions for the state of Nevada.
Okay, so we would be looking for, if we wanted to do something to make this somewhat legitimate for those people and for the clients, so that we don't have an underground industry, we would have to create some type of regulation that falls under this 644.190 and create an exemption for those services. Is there any appetite for that on this committee at this time? Seeing none, I don't have any. We move on. Okay. The other item here would be 644.460, styling of hair pieces, restriction, additional penalties for those who engage, blah, 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 place of practice. Since we don't want to do anything as a board to legitimize doing anything outside of a cosmetological establishment, wedding or otherwise, I think that all of the NRSs I had listed here would not need any type of revisions. Is there any comment? Does anybody believe that any of these need a revision?
I don't think if they fall under the same disposition in which we're talking about, I don't think
you want me to
need
read these NRSs for you? I can do that very quick. We got 460. Actually, I got it all. I actually prepared for this meeting. I actually wrote all this stuff down. All right, here we go. NRS 644.460 exemptions. The following persons are exempt from the provisions of this chapter, and photographers or their employees insofar as their usual and ordinary vocation and profession is concerned. If the photographer or his or her employee does not advertise cosmetological services and provides cosmetics without charge to the customer. So in this here, if someone advertises that says that they're a photographer and they're doing hair services as part of that, they would be in violation of this NRS statute. So you can't just advertise that you're doing hair and then show up with a photography license and allow that and have that be legitimate, because here it says they don't advertise the cosmetological services. Well, in the ways, the next thing here, so that would be this. So we could, the unlawful practices without a license is 644190, and that was again, we had the photographer in there, and other things that are exempt and unlawful. And then we get into the styling of hair pieces, and I brought this up because a lot of times wedding updos have hair pieces and things of that nature, and it says here that cosmetologists have to do it. Anyway, so that was just something I brought up. Okay, what else you got? 644490, additional penalties for a person who engages in certain conduct without license. Authority of the board to issue citations in order to cease and desist administrative fines and appeals. It says the board may issue a citation to a person who violates the provisions of NRS 644.190, which was the very first one that we talked about, the unlawful practices. A citation issued pursuant to this paragraph must be in writing and describe with particularity the nature of the violation. The citation also must inform the person of the provisions of subsection 2. A separate citation must be issued for each violation. So this is basically what we would fine someone for doing that. Should a client complain and we know who did it and we investigate and find that it was done, these are the penalties for that. I don't know if that needs any revision or anything. I just thought we should look at it because it's part of this, right? All right, 644380, place of practice, licensed cosmetological establishment exceptions. It says, except as otherwise provided in this section and NAC 644385, a person licensed to practice cosmetology may practice only in a currently licensed cosmetological establishment. So if someone complains and says that they don't like the hair services, then we can, and we know that they have a license, and we can investigate and use this particular NRS as the complaint, right? As the basis for the complaint, right? In the event of an emergency, a person may engage in emergency practice. A licensee may perform services outside of a licensed cosmetological establishment if the customer to receive the services has received a letter from his doctor. Now this is where I thought, when I was looking this over, I thought, well, if we were going to do something, this would be the section that I would have placed it, in that we could say a licensee may perform services outside of a licensed cosmetological establishment if the customer to receive the services was from out of state, or I don't know, I really couldn't come up with anything, but if we were to do it, that's what we would do. All right, those were the only places that I felt we could add things in or take things or modify things to do that. Now that I've read those, is there any discussion on the board's behalf that they would like to add, modify, subtract from these NRSs in order to more legitimize wedding services outside of a cosmetological establishment?
Perry, I just really think maybe this would be a topic that we could put up and talk about, because where I'm somewhat confused because I thought we weren't going to talk about it and we're still talking about it. So I'm confused.
Well, here's what on the agenda I had written that we were going to discuss in particular the NRS 644.190. That's what the agenda item is, along with 460, 475, 490, 380. What we did is we came along and we took up the staff recommendations and staff comments as the first part of this discussion. And we basically decided that we were not in agreement with the staff recommendations except for possibly the advertising requirements, and that we're going to move that and talk about that as part of a more broad.
But they can't advertise and use their license because they have to work under a photographer. So I'm confused why what we're talking about now. Because they can't put their license in the newspaper or Craigslist because they can only advertise as a photographer.
Koki, I'm just recapping what we've talked about so far. And that's all we're doing. We're not discussing anything. I'm just recapping. And all the discussion about advertising will happen at the next committee meeting because that's going to be a larger, more broad subject, and this will be part of that subject. But I'm just recapping that as part of the agenda item, we took up the staff recommendations, decided we didn't like them except for possibly the advertising one, which we will take up at the next meeting. And I'm going down the list according to my agenda of the various laws that may possibly be revised, added to, subtracted from in an effort to more legitimize the wedding services outside of a cosmetological establishment. And it's our job here to try to create something that we feel is palpable to both the legislators, to the consumers, and to the hairdressers. And the way that we are working this is we're trying to create very specific recommendations to the legislature of 2015. Much like you saw all the proposed changes from the last time, we've gone through the actual statute and created our own numbers and created suggested wording to them and so on and so forth. So all I'm asking for at this moment in time is for these NRSs for you to look them over and decide if there's some form of change you would like to propose that might fit this the wedding services outside of a cosmetological establishment for the staff here, or should we continue to do business as previously as we have been? And I'm inclined to believe that based on the discussion here, we should be doing business as we have been in the past and nothing should be changing here. Unless you come up with some concept or some idea to make changes to these specific NRSs.
I have nothing. Annie, did you have something to say?
Yes. Actually, when you're talking, it's kind of like your regulations they actually tell you how to do the laws. Your NAC 380 is explaining the donated service under 385, and it's also emergency services. Those are the two exemptions of working outside of a licensed establishment. But when you're talking your NRSs, like for your photographer, they're like two different things. One's the law and one's the how to.
From what I understand, this NAC 644380 would take as its basis the exemption under NRS.
Yeah, that's the exemption under the NRS.
Right. So my question, just out of curiosity here, is the word advertisement. If the NAC is supposed to use the NRS as its basis, why did we put into the NAC advertising? Let me see. Let me read this again. Where is it?
Because when you're referring to the NAC and 380, it's telling you that the licensees can do this and how they can do it, which is like the emergency services or the donated services. When you're going to the exemptions on the 460, they don't have to be licensees. They're exempt. But when you're talking under 380, we're talking about licensees.
I think if you add the word photography anywhere in there, this is my personal opinion, that you're gonna have a lot of upswing in cosmetologists that get business license for photography.
Well, that may be true, but according to our laws, it says that they can't advertise cosmetology services. That's not part of it. If they're going to do that and they're going to advertise for these services, they have to advertise for their photographic services and not their cosmetology services.
But the photographers can advertise a complete package, Perry, of hair and makeup.
Not according to this, they can't.
But the photo.
For photographers can. Their license is totally different than what we're talking about a cosmetologist here, but a photographer can advertise. The photographer that has a license can advertise for that he does or she does hair and makeup. It's been going on for at least 30 years I know of, that you get those packages and it goes through the photographer.
I think putting that in there is gonna just...
Pokey, we're talking about it. The rules and regulations here, and I understand that they have been doing that and they do that, but what NRS or NAC do you see that they are using to justify that?
I don't see any because we don't regulate photographers. Photography, we don't oversee anything to do with photographers. We're only hairdressers, makeup, nails, hair. So we don't regulate photographers. It's not our area. So we're really kind of stepping out of our area and trying to regulate somebody else's area if we had photographer in there.
Now, I know it does talk about in here movies and doing things on movie sets. Is there some way we could be able to use that statute as a basis to base the photography under, which would make more sense?
The photographer.
I don't see that to be true.
Miss Annie had something to say.
The photographer is exempt from this chapter, from 644. So he's not under us. But when you're talking licensees, I think originally we were talking about how do you get your licensees involved in something to where they're legal and it's okay.
Yes.
So we're mixing both. You're mixing them up.
Yeah, the way I'm hearing things up here, we're not interested in making it legal. Is that correct?
Okay, so that's your opinion. In other words, you don't want the licensees to be able to partake of any of that. Is that what I'm understanding? Is that what I'm understanding?
I didn't hear what you said.
He didn't hear you, Annie.
I said, is it my understanding that you don't want the licensees to partake of any of this outside of the licensed establishment?
From myself and the board members.
Not from this board member. I think we should.
Let me ask a question from the board members. Is there any board member that would like to make wedding services outside of cosmetological somewhat legal?
Well, I don't think there's someone. I think I'm probably the only one that would wants it. So, but I'm saying there's one of us I would like to see us. I actually would like to see more conversation on it. I don't want to just have one meeting and that's it. I think there's a lot more pros and cons, and I'd like to hear more about it. I'd like to actually see it tabled and have a little bit more refined discussion on it.
I think there needs to be more discussion too. I mean,
see that that's going to be happening. If that's what this committee is about. You know, this committee is going to do all the discussing so that the board, at the board meeting, doesn't have to do that, and we don't have to bring it up further. That's what we're here to do.
I don't know if I would like, I mean, I would like to see something that like this legal, but more on the lines of a registry, as in registering themselves, so we know who's doing it, and maybe each time they do it, they go on and put it into their registry, or at least we are aware that they're doing it, and we have some kind of stipulation and awareness But
So what I'm hearing is that.
I think that there needs to be more, I think there needs to be more discussion and more.
One second here. Whoa, slow down, everybody. I'm trying to run this meeting here. So April, what I'm understanding is that what you're asking for is that under 644.460, that if we place something that says that a licensed cosmetologist is registered with the board to do wedding services, that they would be exempt.
I don't think they would be exempt under any cosmetological laws. I think that they're registered with the, I think there needs to be more conversation on this. This is, I think, to me, it feels like something that they need to register with the board for, to bring the awareness to the board, to bring the awareness to the public, so the public can go on the website, look at their license and say, this person is registered with their board. They have, either have the awareness and the instruction to be able to go to a hotel, home, whatever, to do services outside the realm of the cosmetological establishment.
Well, April, the way I read this is that if we don't exempt them, then we have to go through the entire law book and create specific regulations for those exact moments when those cosmetologists are in a motel room, similar to, say, a mobile establishment. So the only way to allow someone to do hair outside of a cosmetological establishment would be to exempt them if we had a registry system. Unless, of course, you have the appetite to go through each law one at a time and figure out how that applies to hotel services.
Annie Curtis, if you exempt them under 460, the board has no control. Registering.
I understand that. That's what I'm talking. That's exactly what I'm talking about, because that's how I see the only way that we could somehow allow them to do a service outside of a cosmetological establishment is to exempt them, because there are far too many laws on the books that says this is how we do business as a licensed cosmetologist. And I think if we start giving some sanction to them, that now we're going to have to go through each and every law and figure out that when such and such a person is in a hotel room, they have to lay down a non-porous service, and there's a lot of stuff that we would have to go through to legitimize that. The easiest and really the best way to do that, it would be to exempt them from our services and from our laws, much like we have other exemptions such as the photography and other things.
So you're exempting our own licensee, is that correct?
Yeah, I have any.
That's what I'm hearing you, if we were to register someone and give them a registry, then we could say that a registered cosmetologist, a wedding service registry would exempt, if they signed up for that, then they would be exempted from the cosmetology laws at the time. And we're basically relying on them to be good cosmetologists and do a good service. And anyone that is not registered would then fall under the rules and regulations of 644 and would be subject to our penalties as such.
Okay.
Also stating that the people that you allow.
Also, when you're registering people and you don't have any guidelines, your board has no control. You have no citing ability.
Sort of guidelines.
You have no citing. You have no ability to cite them. So, because as we have now, the threaders, all they do is after the first of the year, they register. We cannot go in and cite them on anything. So registering does not give you any
Credibility or
authority.
authority.
And if you're exempt, you can't even entertain it. You can't deal with any of the situations. That's what 460 means.
Correct. And to me, if we wanted to somehow legitimize wedding services, if we provide an exemption, it would generally allow that to occur by registering and exempting them. And thus, instead of having a whole lot of licensed cosmetologists who are doing business against the against the law, against our existing law, we give them an option to do business within the law.
If you think about it, we as cosmetologists, Kogi, are completely knowledgeable of wiping things down, going in with clean implements. We've done all that testing. So if a hairdresser is going to go in there against the law that we've put down to protect the public, the best thing we can do is educate the public that if they use a hairdresser that is not licensed, they're at buyer beware. If they use a hairdresser that's licensed and they happen to burn their ear or nip their ear when they're cutting their, fringe or whatever it is, then we can hold them, accountable to our standards. If you put some sort of registry together, it is going to be chaos. There's no way we can walk in, there's no way we can, it's just going to be ludicrous, you guys. I think that if you keep them in a professional state, we can regulate that. And if people want to use people outside, consumer-driven, their sister's mother's brother cutting their hair in the hotel room, let them do it. That's that buyer's beware deal. They're going to do it, they're going to do it. But I don't want to be accountable for that person cutting hair that has no at all accountability to this board.
I'd just like to make one comment too. If you exempt them, then all hairdressers could then become wedding planners or whatever, and they don't even need to apply by any of our laws. So I think exempting a hairdresser for that reason, I just don't think an exemption would work. Why even have the cosmetology board? So there would be no education needed, no nothing. You just go down.
That says this is how we could make it happen.
So I don't like the thought of exemption.
Either do I.
Okay. I'm not for it either. I'm just stating that this is rule-wise. When you're creating a rule, this is how we have to go about it. So, moving on. Now we're going to be talking, Mr. Landry.
Before we do, Gary Landry, Executive Director. Before we move on, I just wanted to make clarification on one point. When you talked about the purpose of this committee and the results of the committee, this will go to the board, full board quorum, and it will be open to discussion from both board members and the public at that time. So anything that's discussed and agreed to here will all be reopened up again for full discussion if the board so deems or wishes from both the public, required by the public, and then also by board members.
Absolutely. Okay, so let me find my agenda here.
Do we need to call for a quick bathroom break, Perry, or?
No, we can do that, because this item number 5 that we were on is done. Basically what we're doing here is saying that under that item, we as a board have no appetite for making any changes and business shall continue as usual. Okay, so end of item and break time. We take a 10-minute break, is that okay, April?
Oh, that's.
How about 5? How about 5 minutes?
5 is fine.
I don't care. Okay, so we would like to consider moving item number 7 in front of item number 6. I have no objection to that. Anybody else have an objection to that?
No.
No.
Okay, so then let's do it. Let's move on to item number 7. Review and possibly formulate revisions for submission to the 2015 legislature to NRS 644.248 hair braiders scope of examination. All of the other statutes relating to scope of examination, such as cosmetologists, electrologists, hair designers, nail technologists, demonstrator of cosmetics, estheticians, NRS 644 through 240 to NRS 644 through 247, have the following language: such other demonstrations and tests as the board requires. Adding this language will keep our statutes uniform in their language. All right, as board members, does anybody here have discussion on this?
Perry, I would like to turn my time over to some of the schools here that would like to speak, because I know they have to leave. So would someone like to get up and speak in my time slot?
Well, we're just adding the same.
We're going to talk board members. We're going to talk board members first. Linda, did you have anything?
Aren't we just adding the same thing that we did last time onto it? Isn't that what you just said?
All we would be doing is just, all we're asking is that such other demonstrations and tests as the board requires be added to the NRSs to make it consistent with everything else.
Yes.
Any discussion from board members?
No.
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 No discussion from board members, so I would like to call for public comment now. Anybody from the public who wishes
Why
to
don't you
speak
step
on
up
this
and tell us
behalf,
what you have to
please
say?
come forward.
Okay.
She's coming up, Perry.
We're forcing her to come up and make comments.
That's okay,
Flip
I'd
the
love to
switch.
hear from her.
You need to turn your mic on.
Gwen Bramo from the Expertise Cosmetology. I was just making sure.
I can't hear you, somehow your
Can you
mic's
hear me
not
now?
on
Is
or
it on
something
or off?
like that.
Here, you want
Okay, is it on? It's on.
It's on.
Gwen Bramo from the Expertise Cosmetology. I just wanted to make sure with the hair braiders, this particular scope of examination meant that you were just going to be adding in that language because there was no language there at first or something?
That's it.
Yes, are you asking a question of us?
Yeah, I was asking a question.
If you were just adding in the language, that's all that was being done for that.
That is what this particular item on the agenda is about, is just adding in that one phrase to the NRS 644248 hair braider scope of examination would include an item, such other demonstrations and tests as the board requires.
So it's just the same as all the other examinations, right?
That is correct.
Okay, because I didn't know it wasn't there, because I had heard in the past that there were, I'd known in the past that there were other braiders that had taken that examination, and I didn't know that it wasn't there from the very beginning. So.
Yeah, what this would allow us to do is in the future, if something were to come up, let's say that we end up having some violations from hair braiders that we feel weren't covered by their curriculum or by the testing, we could then add some questions or add something to the test to more specifically make sure that the hair braiders understood that particular topic. It's really not something that I think we're really looking at doing anything with. It just gives us future options and continuity within the law.
Okay. Thank you.
Thank you for your comment. Okay, so this one's pretty straightforward. Would somebody like to make a, would somebody like to discuss this further?
I'll make a motion to move it to the board.
Okay, I'll
Do I
take
have a
that
second?
motion.
I'll second.
I'll second.
Okay, seconded by Jeanette Benaldi. All in favor?
Aye.
Aye.
Aye. All opposed? Unanimous? Pass. Okay, now we're going to move back to number 6. Review and possibly formulate revisions for submission to 2015 legislature to NRS 644.473, unlawful acts concerning cutting men's hair and practice of barbering. This law may require clarification. Other laws, regulations that may need to be reviewed under this topic are NRS 644.0225, cosmetological establishment defined, NRS 644.200, cosmetologist qualifications for examination, 644.204, hair designers qualifications for examination, NRS 644.360, display of license, limitation on person to whom space may be leased, limitation on persons who may be employed, NRS 644.475, styling of hair pieces, restrictions. So, under 644.473, that law states that it is unlawful for any licensed cosmetological establishment to represent itself to the public as primarily engaged in the business of cutting men's hair, or any person licensed pursuant to this chapter to engage in or act or practice which constitutes a violation of subsection 6 or 7 of NRS 643.190. Now, here's where I have an issue with this particular NRS. I don't think an NRS should refer to another NRS outside of itself, and I think it should be spelled out. This NRS 643.190 is a barbering NRS. That's the barbering code. because we were the 644. And when we teach our cosmetologists, we don't hand them a barbering or law book. And so they basically look at this and go, okay, right? This pretty much requires that a person actually take the time to go look it up and have it available to them in some other way. And I'm not too happy with that. I think that it should be spelled out, and that the NRS 643190, if they want to put this in our regulations, that it needs to be spelled out. And that's my particular issue with this particular NRS. Is there any discussion on what I just brought up?
I completely agree with that. I don't even know what 643 says.
It basically says any licensed cosmetology establishment to represent itself to be primarily engaged in the business of cutting men's hair. It also says that you can't have a barbering pole or anything resembling a barbering pole out in front of your salon that basically promotes or gives any consumer the idea that you might be a barber. So all of our cosmetological establishments that do a tremendous amount of men's hair can't put a barber pole up that says, we do more men's hair and want to do more men's hair. And that's really what it says. But I think that that should be spelled out under this particular NRS for clarification for all of our new licensees as well as existing licensees who don't want to go and look this up in some other way, so that they can be compliant with it and understand it in its entirety.
So Perry, so you're saying you want to put up a barbering pole?
No, I'm not saying that at all. What I'm saying is
I'm sorry, I misunderstood.
That's okay. What I'm saying is that this law is unclear because it references a law, an NRS, that is not under our jurisdiction. And it makes it difficult for cosmetologists to read this law and comply with it because they don't read it. I'll read it to you in just a moment. Let me find it here. Hold on a second. Let's see here, 6443190. Okay, so 643190, unlawful acts concerning practice of barbering. It is unlawful for any person to engage in the practice of barbering in an attempt to engage in the practice of barbering, blah, blah, blah. Okay, but it specifically states here subsection 6 and 7. So subsection 6 of 643190 states, for any person licensed pursuant to chapter 644 of the NRS or any other person to A, hold himself or herself out to the public, solicit business, or advertise as a licensed barber or as operating a licensed barbershop. B, use the title or designation barber or barbershop under circumstances which would create or tend to create the impression to members of the general public that the person is a licensed barber or is operating a licensed barbershop. Or C, engage in any other act or practice which would create or tend to create the impression to members of the general public that the person is a licensed barber or is operating a licensed barbershop, unless the person holds, as appropriate, a license as a barber or a license to operate a barbershop issued by the board pursuant to this chapter, or the person is operating a licensed cosmetological establishment that is leasing space to or employing a licensed barber pursuant to NRS 644360. The second part of that is number 7. For any person licensed pursuant to chapter 644 of NRS or any other person to place a barber pole in a location for which would create or tend to create the impression to members of the general public that a business located near the barber pole is a barbershop pole, unless the operator of the business holds a license to operate a barbershop issued by the board pursuant to the chapter of the business, is a licensed cosmetological establishment that is leasing space or employing a licensed barber pursuant to NRS 644360 as used in this subsection. Barber pole means A red and white striped vertical cylinder with a ball located on top of the cylinder, or B, an object of a similar nature regardless of its actual shape or coloring, which would create or tend to create the impression to members that the general public that a business located near the object is a barbershop. That is what we are stating we will agree to. I think that it's incorrect of us to force our cosmetologists to go to this statute in their law book to determine that. I propose that that we make revisions to this that clarifies and writes out their items 6 and 7 in our code here, so that it's clear to everyone who's reading our books.
Perry, this is a very interesting statute, as in, I know for a fact that there has been a lawsuit under this statute, which I will find you because I know the prosecuting attorney. They had a Title IX issue, which was a gender discrimination issue, not a barber pole issue, because it said men's hair. So I will find that suit and I'll bring it to the next meeting, and I will email you that information, everybody that information, so they all have it. I think that this is something we need to look at. I think we need to look at that as well and see what that lawsuit was about. I know that it was about an advertising of a men's only salon, and I don't want to get too specific or off topic, but I will get that information to you. I think that this is an interesting statute. I think that it needs to be looked at, and from what I heard from that lawsuit is they were saying it was unconstitutional. So this particular NRS 644-473, I think has come before courts before. So I think it's definitely a good statute for us to be looking at.
Well, I'm not trying to challenge what it says, and that's not the point of this.
I understand that. I just think that it needs to be looked at even deeper to see that if it possibly is unconstitutional.
I have a question here too. I have no problem with how this law reads. The only thing that I read in here, if I'm understanding this correctly, is that a hair salon may not have leased space to a barber. Is that correct, Miss Annie?
No, that's not what it says. I'm sorry.
Okay, what was your question?
My question was, does it say, can a salon lease space to a barber in their salon?
They can lease space as long as it's separated out with the 6 feet walls and a lockable door.
And a lockable door, okay. Because I didn't see anything wrong with what was being said in here myself, but.
No, and we're not trying to judge the constitutionality. That's for the legislature to determine when they do that. I'm not trying to change this, and all I'm trying to do is clarify it for our licensees so that they don't have to move out of their law book to read exactly what it is. Because what happens is, in practicality, there's rumors out there that say that we can't shave because we aren't barbers, and that's where we draw the line. The difference between a barbershop and a salon is shaving the face or shaving the back of a neck or something like that. And none of that's true. We can or can't based on our own laws, not on the fact that it violates the barber's code or something like that. And I'm very interested in making sure that this particular NRS is clear to a person reading our book at the time they are reading our book. The constitutionality of this or not would then be determined later on at the close of a lawsuit when somebody wins or loses and the legislature has to take it up based on constitutionality.
I think if we're looking at the law, we should look at the whole law, though. The whole
My
NRS.
understanding, but the 644 or 473 was referring to the barber pole itself.
It's
And who's
referred.
practicing in the licensed establishment. If you put the barber pole out, it should be barbers. I mean, that's pretty clear. I don't think that's to be challenged, but there are laws in there regarding advertising to men, but we're going to get to that.
Right.
Is that correct?
Yes, we're going to get to
So it's
that.
an
For-
additional-
in this, I'm trying to take this one step at a time. And right now, my issue with this law is its reference outside of our law books, because I want to see our cosmetologists read exactly what they are agreeing to and what the law is without having to move outside of our law book into somebody else's law book.
Perry, Miss Annie would like to speak.
Yes, Ms. Annie?
Okay, actually, that law is just mainly saying that you can't hold yourself out as a barber. And I think as you were reading it, it also referred back to our statute, which is covered under 644, NRS 644.
Correct.
Am I not correct?
That is correct.
Pardon?
Yes, that is correct.
Okay, so it's just a matter of the two laws intertwined for the clarity. In other words, that's why it's there.
Correct.
Not limiting it to just the number, the NRS number, but
And-
actually the wording down in the book. That's all he's saying.
That's
And
all.
I agree with that. I mean, why is it that it's obscure?
It's
Right.
really there just
So
to say that
that's
you
how-
shouldn't hold yourself out as a barber.
Correct.
I never knew that is what that meant. You know what I mean?
Right,
I mean,
and most of the
know
people I talked to.
Well, I could have, if I used my mind, referenced it, but I wasn't interested. I just assumed the rumors that could mean all of the things we've always heard about. Men's cutting and shaving and this and that, but it really has nothing to do with any of it. It's just about not making yourself out to be a barber by putting a barber pole in front of your establishment. That's basically what it says.
I didn't understand. Are you talking to?
So would you like to make a motion?
I make a motion that we allow the wording to be followed behind the numbers, the NRS 643190.
Correct, to include, basically to write out, what I'm getting, what you're saying, is to write out subsection 6 and 7 of NRS 643.190 instead of referencing it.
That's my motion.
Very good. Is there a second?
I'll second that.
All in favor? Aye.
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 All opposed?
Aye. Aye.
That would be. So we have 3-2. Could we clarify that? So Perry Nixdorf, aye. Jeanette Canaldi,
Aye.
aye.
April Long, aye.
Linda?
Oh, I'm sorry. I said nay.
Are you a nay? You nay? Okay. Koki, you're nay?
Nay.
Okay. Passes 3-2. All right. So we'll add that into as a change. All right. So the next thing is the cosmetology.
We have some public comment on that one. I'm sorry.
Sure. We'll entertain that.
Okay, Gwen from Expertise. I think I'm a little confused. So what we're saying is that as long as we don't have a barber pole and advertising that we're a barber shop, that we can still, as a cosmetologist, you can still service men's haircuts and shaves or whatever they do, as far as practicing, as long as you're not considering yourself as a barber.
Within your scope. So if your license says you can do these things, you can do these things. You just can't portray yourself as a barber by putting a barber pole in front of your establishment.
Miss Annie, can you help us too?
I think I'm confused here.
Isn't a salon can't put a barber pole outside if you're doing cosmetological work? Is that correct, to
Why would you
simplify?
want to?
Yeah.
But if you're hiring barbers
You
in
can
a
hire,
separate section, you still can have a pole. So can you still have a pole if you have 2 licensed barbers in your salon?
The barber
Yes.
can utilize the pole.
Right.
The cosmetology industry can't. If you have a barber there, you can have a pole.
Okay.
If the
But
barber,
as a cosmetologist, you can't service, because I was always under the
Okay.
impression that you can only service X amount of men clients.
yeah, but yes, that's the indication of the law. But you can't do the shaving. You can't do any of the thing that the barber does unless you are a barber.
so you can't trim a mustache, trim a beard,
You can't
you
shave.
can't
Shave.
shave.
You can trim hair.
You can trim
With a
your.
You can trim hair.
You trim a mustache.
You can trim hair,
You can't
but you
shave.
can't shave.
So there's no set amount of clients. You can have as many male clients
Yeah.
as.
If
you
it's
service.
unisex, you can do what you do.
Oh,
No one counts them.
I was glad today.
see, I
Okay,
learned
so,
something
so I'd
today.
like to clarify something here momentarily. Ms. Annie, you said we can't shave. Could you please clarify which NRS and or MSC?
According to the law, you cannot shave.
Please clarify which one?
Which law is
Which
that?
one?
What NRS is it?
According to for cosmetologists, there is no shaving under your scope of practice.
Could you show me which law that would be?
That would be under your definition of a cosmetologist. The scope of practice does not include shaving.
So that's under the definition of cosmetologist?
Yes, it does not include
That
shaving.
would be section 644.
It would be under NRS 644.023.
Oh, 24? Oh, sorry.
644.023, the definition of cosmetologist. It does not include shaving.
But it doesn't exclude shaving either.
Pardon?
It doesn't exclude shaving. It says that I may remove superfluous hair from the surface of the body of any person by the use of electrolysis, okay, or by the use of depilatories, waxing, tweezers, or sugaring, except for permanent hair removal with needles.
Does not include
I would
shaving.
argue that if I could wax hair, I could shave it.
Pardon?
That because it doesn't exclude it?
Under 644.023, I mean, I'm just trying to clarify this because you see, this is the issue that I'm trying to bring up, is there's a lot of people out there, a lot of cosmetologists that don't understand the difference between barbering and cosmetology. And we've always been told that we can't shave or we can't do this or we can't do that because it's a man you're doing it on. And I don't read that anywhere in here that says, for instance, I can't shave a man's face.
So Perry, would you want to include an exclusion on 644.023?
Actually, this is telling you what you can do.
Yes, but it doesn't.
And it doesn't include
It's
shaving.
exclusive of everything else, right?
In the definition of services, it is exclusive. If it's not on this service list, you cannot perform it, like laser hair removal. You can't prescribe pills for weight loss. Anything that's not on this list, you as a cosmetologist cannot do unless you change the law to say you can.
Got it.
I have a
You
question.
can't cut, trim, or shave the hair, and that would be hairing. You could cut, trim, or shave a beard, but you can cut. You can't shave. There's nowhere in the cosmetologist defined that allows you to use shaving techniques.
But I could use a razor to shave hair.
That's correct. Because it does allow you to cut. You can't cut hair with that.
So I could argue that I'm shaping that hair very close to the skin. Just to make an argument.
No, absolutely. That is an ambiguous point. It's how close does it have to be before it is considered shaving? And then I probably have to look in the Nevada state law, NRS 633, because I'm sure they have defined shaving.
Yes. So, but you see, also under the Nevada Board and Commissions manual, we're confined to our 644. All right, and that's all I'm saying. And in this particular NRS, okay, all I'm really trying to do is clarify it so that everybody understands it, and every cosmetologist will be bound by what's in this book, whether they shave or not, or the argument of whether it is or isn't trimming the hair closely. It's not important. It's just the perception that barbers do one thing and cosmetologists do another, and I want it clearer so that it's barbers do men's hair and cosmetologists don't advertise that they do men's hair.
Perry, do you,
And specifically for, just to clarify, what Ms. Raymond was bringing up about, the number of clients and how many are male, how many are not, there's nothing in the law that would preclude you from doing a male-only business as a cosmetologist. You just can't represent or advertise it as male-only.
That's the way I
Well,
understand.
wait a minute, you can't represent it with a barber pole. as male.
Or advertising.
You cannot represent yourself as a male-only cosmetology institution according to our law, the existing law.
Right.
And that is the one she's talking about for Title
Yes.
IX.
Correct.
Right.
And where is that law that connects to?
Perry, are you saying, I don't know if I'm misunderstanding this. The only thing that keeps us different from the barber board, or Annie, maybe you could answer this, is the shaving?
No. What keeps us different from the barber board, according to our laws, is NRS 644473 that we just approved here, to add their language into our regulations so that it's clarified. Really, it comes down to advertising that you're a men's only salon or hairdresser. And that's about the advertising. It doesn't say that you can't be a men's only. It just means you can't advertise that you only do men. Because the barber board does men. See, just like the barber board, I don't think they have anything that says they can't do women's hair or advertise that they do women's hair. I don't know what they are. I don't really care. But I care about that this is clear.
Well, can I just add, so what we're trying to do is disperse any kind of rumors. So this is already in place. It's already
Correct, it's already law,
clarifying it.
understandable.
So we're just clarifying it by adding the 643 with the words behind it. So, and then that takes us to April's point. So she's claiming that which I find is really interesting, we can't advertise to just men, has been argued upon and won in the lawsuit as unconstitutional. I think that needs to be addressed as well. So is this the spot where we would do that?
No, that would be the legislature that does that.
I'll find
I
more
don't have
information
that.
on the case. I'm not sure of the outcome of the case, but I will find out.
If you forward that information to me, I will perhaps bring it up in another meeting.
Absolutely.
We just advertise to men. We are not allowed to.
This is it. This is the law that says you. do not
Perry, I have a question.
Yes.
My question would be, is you're wanting to put this after the law so that it makes it clearer for somebody to read. Instead of just, why not just put the number if that's what you want, instead of putting the whole law behind it? Or the whole definition behind it? Because our law book will be so large and it'll be hard to follow, I think, is what I see happening.
Well, it's much harder to follow if you can't see it. That's my point.
If you had,
this is. Cosmetologist owns a law book from the barbering board.
It's not even in our book. You have to go to the barbering board to find the law.
No, it is in the book.
No, it's not.
No.
Only the reference to 643.
That you can't practice as a bar. Is that in the book, Annie? I thought it's in the book that says you can't practice as being a barber.
Actually, it's making the statement when it says you can't predominantly do men's hair. It's giving you an idea of what that law is saying.
But doesn't the law also say I can't have a barber pole in my book here? This book here?
No.
Well, you have to go, just like anyone that would want to know what our laws are in depth would have to go to the website and look up the laws. For the barbers, you'd have to do the same if you wanted to know exactly what they say. But the essence of that particular law is that you can't do men predominantly.
Well, several years ago, didn't we have, was it for men's only or something? There was a salon, a barber thing that came in front of us, and they were doing hair pieces and that, but they only advertised for men, and we wouldn't allow them to do that?
Because the law does not allow you to only do men. But
Right.
there are women that need hair pieces and
Right, but they couldn't
Things couldn't
advertise
they couldn't
as
advertise
men
as
only.
predominantly
That's
men
gender
only.
discrimination. That's
We're
unconstitutional.
just trying to clarify that. All right, so moving on. NRS 6440225. I read this, cosmetological establishment defined. Now, I was rather intrigued by this last portion of this sentence. It says, cosmetological establishment means any premises, mobile unit, building, or part of a building where cosmetology is practiced, comma, other than a licensed barbershop in which one or more licensed nail technologists practice. I'm very confused about this, and I was wondering if I could get some clarification from staff.
Annie,
Which-
644-4473.
Do more.
0225.
I mean, 0225, I'm sorry.
My reading of it, my reading of it is, you cannot call yourself a cosmetological establishment if you're a licensed barbershop with nail techs. So it's kind of a protection on, they can't call them, we can't call ourselves, our profession, barbers, they can't call a barbershop a hair salon or a cosmetology salon or a cosmetological establishment, specifically. They can't call themselves that if they're a licensed barbershop with licensed nail technologists practicing in that. That's in a separate area, door, locked door with 6-foot walls. They can't, just like we can't use the barber pole, we can't call ourselves barbers. The barber cannot call themselves a cosmetologist or call their establishment a cosmetology establishment if they employ cosmetology professionals. And to your point, Perry, it only addresses nail techs. If they employ anyone else,
They could. Yes, so
it's nail techs only.
Next only, so they can have a facial person, and now they're a cosmetologist.
That's correct, but they would have to have a cosmetology salon license to call themselves a cosmetology establishment, because further in our NRS, it says what a cosmetology establishment is required to get as a license.
Exactly. So, is there, I think because this is confusing, I think we need to strike it. Because of that, those requirements that say this is what a cosmetological establishment requires. And it says, blah, 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 all the things it says. And that would have to be true, period. And if a barbershop wanted to call themselves a cosmetological establishment, they would then need to apply as a cosmetology establishment and comply with all the rules and regulations thereof. And so this is just confusing language, in my opinion, and superfluous in nature and inaccurate entirely. Because we would have to put in hair, we would have to put in all the other things that we've categorize now, hair designer, cosmetologist, blah, blah, blah. We'd have to put all that stuff in there to make it clear.
That's correct, and the one thing that I would anticipate as far as pushback from the barber, the barber board and the barber lobby, is that if we do strike that, then any barbershop that employs any cosmetology branch, a nail tech, an esthetician, a hair designer, or a cosmetologist, would now have to be licensed as a cosmetological establishment. So it's a new fee, a new license for them. I'm just giving you the pushback that's going to come from the other side, my anticipation of it.
But if we hire, we'll get into the hire in a minute here. If we lease to a barber, they still are not in the cosmetological establishment. We've just leased space to them. Don't they have rules that are similar to that?
I'm not sure. I can do research on that to see if that's the case.
All right. So in absence of that, I'm assuming they should if they don't. And I'm not too concerned about what they do or don't have in their laws. They would still need to come to us and say, I want to have a cosmetological establishment, and then we license them as such if they qualify. And I don't really see too much of a problem if somebody wants to have a cosmetological license and a barbering license in the same space, and they come and they meet all the requirements of both. I don't see a problem with that, personally, from a law point of view. So I would like to see that we strike this and just put a period instead of comma under cosmetological establishment defined. Is there any discussion on that?
So can you go over how it would then read?
Yes, it would read, NRS 644.0225, cosmetological establishment defined. Cosmetological establishment means any premises, comma, mobile unit, comma, building or part of the building where cosmetology is practiced, period.
Makes sense.
In the future, could we maybe get that ahead of time, Perry, so that we can all read it? Because I hope we're not leaving something
For
out.
your information.
It's right there.
For your,
Where?
yeah. I did put it under number 6, NRS 644.73 that we were talking about.
He's going to write everything, he's going to eliminate this part here.
That makes sense, Perry. It seems confusing any other way.
Annie, is there any problem with that?
Yes. If you take out the part that where it says the nail techs are allowed, then you would be saying that they couldn't be, because nail techs can go into the barbershop and do nails. If you take that part out of that law, then they wouldn't be able to do that.
So they would not be able to practice in a barber shop.
Right.
So then the law really needs to
currently
be
And
the
that's-
same.
They are currently allowed to practice in a barbershop.
Could you reference to me the NRS or NAC that allows?
That is an attorney general's opinion.
Could you show me that somewhere in the book?
Under manicuring.
Perry, I wanted to let you know I have
It's
to
on
leave.
page 49. Attorney General's opinion.
Okay, I understand. 11:30 you have to leave.
I think it's on 49.
Is that what I just heard?
I'm still looking for it. Let me see. Regulations. I have to look that up. It's just, I can't locate it just now. Hold on.
Perry, while they're looking that up, could I make one recommendation? Is maybe next time we could have Mr. Landry sit up there with you and the girls sit up here with us, because you can't see them and we can't see Mr. Landry if somebody holds their hand up and would like to speak. And I think it might make it easier. This is just a suggestion for thought for next meeting.
Thanks, Cookie, but I believe that the next time we have this meeting, all the functionality of their system will be in place, because they're coping with the fact that they didn't have the correct audio, and I believe that when the cameras are in place correctly, that everybody will be able to see everything. But should that not be the case, I think that's a good idea.
Why don't they use FaceTime? No, I'm kidding, Perry.
It's so much better.
I'm gonna show my age, how about go to meeting?
One of the things that I just want to point out, that one section of wording other than licensed barbershop with nail techs, that is what exempts them from having to get a cosmetology salon license. Because if you define that as not being a cosmetological establishment, then under 64434, it only applies to licensing cosmetological establishments. So by definition, I don't know the chronology of this, but my guess would be the barbers worked with the previous boards to try and get that in. In other words, it's not boards of the legislature to get that in to exempt them from cosmetology licensing.
Well, my concern is that we're allowing a manicurist or a nail technician to work outside of a cosmetological establishment.
By law, that's permitted in current law. Because that's basically what it says. It says that you're not a cosmetologist. I'm sorry, I understand what you're saying. I mean, by definition, the nail tech is not working in a cosmetological establishment by definition of law.
Correct.
Because we've exempted them out of that. I get your point.
So then they don't need to comply with the space leasing or anything like that, right? We're just letting manicurists work in a barbershop.
So there's a conflict, like I see your point on, there's a conflict of law which says any nail tech must work in a licensed cosmetological establishment, which conflicts with saying that a barbershop with nail techs is not a cosmetological establishment.
Correct. So I think we need to clarify that. If we take this out, which would be the easiest way to do that, I'm good with that.
Well, that would be a good argument for Jeanette Belza when she goes before them. It is a conflict of law, so.
Right.
I would suggest rather than having Amy on the spot and having to flip through pages now, if we just move on to either take a vote on that and then maybe move on to the next one, move on to the next one, and come back to
I was thinking about that too. Okay, since it's not easily and quickly found, I'm sure that a consumer could not easily and quickly find that either, and that it's a technicality. So, is everybody okay with dropping that for the time being, unless somebody brings up other information that requires that we bring it back in at a future meeting?
I'm good with it. I think we should.
Yeah, we can drop it, that's fine.
Linda?
Yes, that's
Being
fine.
Nail technologies. Okay. All right, so let's do that. Let's propose that we drop that and move on. The next one that I have is 644 200. Cosmetologist qualifications for examinations. This is where it gets kind of sticky here. All right, this is and was what I found rather interesting. We have in the NRS a statement under item 5, subsection 5, item C. If the applicant is a barber registered pursuant to Chapter 643 of NRS, 400 hours of specialized training approved by the board. They would have to have 400 hours. Now, if we go into the NAC for what we have under place of practice, now what is it here, NAC, where did I write that down? basically, under the NAC, I don't really, under the NAC, it says that we require the school to test them and then to prescribe some type of study, but it doesn't just simply say 400 hours. I mean, since my personal preparation wasn't quite as good as I had hoped. So this would be NAC 115 that we're talking about here, where I believe there's a conflict between the NAC and this particular law. In that it says here under NAC 644115, item number 3, if a barber enrolls in cosmetology in a school of cosmetology, the school shall administer an examination to determine his areas of knowledge. The school may, if it deems it appropriate, excuse a barber from any of the subjects listed in subsection 1. But it doesn't say anything about making sure that they have 400 hours. So, not quite sure by the NAC, in theory, if a barber were to pass everything in the examination and knew everything that he needed to know, then he would qualify to take the test. Is that not correct under exemption of barbers from the circumstances?
So what are you looking for in this? Whether or not they have the 400
I'm looking
hours?
to make sure that I'm looking to make sure one thing is in congruence with another, so that if the law says that they should have 400 hours, the NAC should state 400 hours. And that I think the NAC should state something along the lines that if a barber enrolls in a school of cosmetology, the 400 hours should be determined, the content of the 400 hours should be determined by an examination of his areas of knowledge, is what I would rather see.
I would agree. The way it is now, it could be confusing. We wouldn't allow the barber to sit for testing, for the testing through us, without proof of having taken 400 hours, because that's what NRS says.
Right.
But I think there could be clarification in both sections that you referenced, 200 and 204, to say that in no case shall the course of instruction include less than 400 hours.
Yeah.
So test the person to make sure they're competent in all areas. If they are, it doesn't matter. They still need to take 400 hours per NRS.
And the 400 hours is kind of an arbitrary number to me, because I don't know how many hours a barber needs. And we require 1,800 hours currently by law. And did they get 1,400 hours of instruction somewhere else, or did they get 1,000 hours or 600 hours? Could you go to barbering school for 600 hours in some state, come here and get your barber license because we don't have a barber school, and you can just sort of apply and get it, and then turn around and go to beauty school, put in 400 hours, and in theory, significantly circumvent the 1,800 hour requirement? Right? That's what I'm reading could possibly be the case. Not that it is, but this committee is about trying to make sure that things are clear and consistent from one section to another. The other thing that bothers me is that hair designers and cosmetologists both have 400 hours, whereas we need 1,200 hours what do we need? 600 hours and 1,800 hours respectively, right? No, what is it? Yeah, 1,200 hours and 1,800 hours, but yet we're going to require the barber to do the same 400 hours regardless of whether they're a hair designer or a cosmetologist. I could see the 400 hours for a hair designer and maybe more hours for qualifications for a cosmetologist, Or maybe no. I mean, as a hair designer, basically a barber is a hair designer. He's just doing women's hair for all I care. A barber could just simply transfer his license to become a hair designer because he's not doing facials and manicures and so on and so forth. And relatively speaking, a barber is equivalent to a hair designer in my mind. But yet we're going to require the same number of hours of them either way.
Maybe this was written before we had hair designers.
I'm sure, well, it says here, hair designers, qualifications for examination. Maybe it was just sort of glossed over, and this committee here is to make sure that nothing gets glossed over, right?
One of the things that, one of the other laws that's in place is that if they come from another state, when you talked about, someone going to a barber school out of state and they come here, if they've not passed the NIC in their state, then they would have to sit for the NIC. Not that they would require any more training, but that they could sit for the NIC. Currently, they'd have to take 400 hours, but after the 400 hours, they could then sit, do the NIC theory and practical. And if they pass that, then they get a license. That is a correct sequence of events.
Right. So, now that I've brought up what I saw as some things that we may need to revise, is there any discussion on that or anything else that you know of relative to 200, 204, and the NAC 644115?
I personally like to see that completely clarified, so I think we need to look at that.
Would you like to look at it under NRS, or would you like to direct the staff to perhaps revise the NAC?
I would think the NAC, because it needs to be clear on whether they're going to be hair designer or cosmetologist.
Harry,
And exactly.
excuse me, I'm sorry. Go ahead, Jeanette.
Yes,
I'm done. That's all.
I asked,
Linda, your turn.
I asked April to Google the barber board, and according to her, the barber board requires 1,500 hours.
In barber school, and may be waived if the applicant completes at least a 250-hour refresher course in barber school approved by the board.
So they have 15 and we
And
require
that's
4,
our
gives them 1,900 hours.
Okay.
And they have not had any training in
I know.
skin and waxing and nails if they want to be a cosmetologist. And we require 900, just esthetician alone, don't we?
Yeah, and that could easily be done if we direct them to test for where their weaknesses are. So if they're going to be a cosmetologist, clearly they're going to get nails and skin, right? But they're not going to do a whole lot with hair, maybe perming, maybe not. I don't know what the barbering board requires, but that would be tested out. But so for me, I would just as soon allow this, I would reduce the hair designer down to 300 hours and leave the cosmetologist at, well, I don't even know, I wouldn't even, as a hair designer, if they pass the test, if they want to become, if a barber wants to become a hair designer and passes the NIC test as a hair designer, I'd be okay with that. As long as they pass our test, I don't think they need to go and get more education just because, unless they need their theory, we could say that they could go to school for theory so that we know that they pass. But if they fail, they've spent their money and they have to spend it again. They can go home and read the book.
Are we?
Yeah.
Hello?
Law book, exactly. And they would clearly know that. So, but to me, a hair designer is very comparable to a barber, except, it's our version of the barber. So, personally, I would entertain reducing the hours. If the applicant is a barber registered pursuant to Chapter 643 of the NRS, he may take the test by the board.
Are you? Hello?
And I think we should have 600 hours for the esthetician and nail part of it with Nevada law, because they've only trained as a hair designer, which would equal them to a 1,200-hour training.
Correct.
Right?
Correct.
So they would have to go for the full 1,800 or 600 hours to come up with a cosmetology license.
Just like we would do a hair designer. If a hair designer wanted to take and become a cosmetologist, they have to do a full 600 hours. Correct?
I think that's equal, personally.
I think so too.
They have to be willing to go shaving.
Annie has a comment.
Linda?
Are you talking about the crossover to become a barber or crossover to become a cosmetologist?
Yes, a
Okay.
barber crossing over to becoming a hair designer.
If you're crossing over to become a cosmetologist, you have to be a licensed barber in this state. If you're crossing over to become a barber, you can only be a cosmetologist. You cannot be a hair designer. You would cross over, take the 400 hours. They also have a 400-hour requirement, the barbers do. And then once you take the exam, you would go straight to master barber and would not have to do the 18-month apprenticeship. That's how the crossover works.
That's how the crossover works.
Mm-hmm.
Have you found that to be adequate?
If you want to be a barber that wants to be a cosmetologist, you have to be a licensed barber in this state. Then you would do the 400 hours in the school, take the exams, and become a cosmetologist.
You have 1,900 hours in this
Annie,
state.
how many times does this happen per year, do you think?
Pardon?
How many times per year does a barber do this? Do barbers become cosmetologists on a regular basis?
Not on a regular basis, but I do remember one of our former board member did the crossover, and he became a cosmetologist.
Right. Well,
I think now, from what I'm talking to schools, I do believe now there's more cosmetologists that want to be barbers, that are going to barber schools. So that seems to be the trend right now.
excellent. All right, so let's be contrarian and let's just make this all happen here. I tend to agree with what Jeanette says. I think that we need to go make changes to NRS 644.200 and put in 600 hours of specialized training to be the equivalent of having a hair designer's license and then becoming a cosmetologist, and that would be more equivalent with our current regulations that we have. And I would say that we should take the hair designers and allow them to challenge the test. Because they've already got 1,500 hours in, which is more than the number of hours we would require for a hair designer. And if they pass the test, they pass the test. If they don't, and they need to go to school, then they can sign up for school, and the school can teach them what they need to know to pass that test. But I don't think we have to mandate it.
Can I hear from the school? Do you find that,
Let her come up here. Yeah, that's fine right there.
do you have something that you offer currently for somebody becoming from a barber to a cosmetologist?
Excuse me, could you state your name and school, please?
This is Amy Christensen representing Palm Mitchell School Reno. And we've had one barber come to our school in our existence who wanted to be a cosmetologist. He did the 400 hours. He is now licensed in the barbering board, and we've only had one student in our 6 years existence.
Thanks.
So, you just
So it's not a very common thing.
no, not at all.
Did you have some sort of curriculum in place that you could?
It's actually, we only offer cosmetology. We do not offer hair design, anything like that. We only offer cosmetology program at the moment.
And we,
400 hours?
Yeah.
sorry.
What we had to do is we had to apply for a letter of credit from the board. They gave us a letter of credit, crediting that individual with the amount of hours that they had and what they had to make, do, what was required by board.
Okay.
So, yeah, we have the reverse. we have so many cosmetologists who want to become barbers. I refer them to the barbering board because that's not in our scope to teach them barbering.
Thanks.
And just to be clear, everything that a barber does is simply what we do except for shaving.
Shaving and tonics.
Tonics.
Yeah. Shaving and tonics is anybody who comes from another state, transfer students or anything like that, those hours that they receive for shaving and tonics is not put into their letter of credit.
Now, how does their letter of credit reference back to these 400 hours? I mean, it's pretty specific, it just says 400 hours.
Well, for that, yes. But the reverse person's coming from another state as a transfer student.
Oh, got it.
If they have shaving and tonics required in their state, those hours are stricken from their hours that were transferred to the state board, and then they don't get those hours. So you guys make the determination, really, of what they get.
Right, so what we do is if a person comes in, a barber from another state, we just take their hours at face value that they were given, and then we require beyond that. So this is strictly for Nevada licensed barbers. Okay.
Thank you.
I still would like to propose 600 hours for qualifications for cosmetologists for a Nevada barber, and allow the hair designer test to be challenged.
I agree with that.
April, do you have
I don't-
comments on this?
I don't have a problem with that. If they can challenge it and they can pass it.
Linda?
I'm sorry, are you meaning you want to change it to 600?
Yes, what I'm asking is if you would be amenable to changing NRS 644-200 to item number 5C to include 600 hours of specialized training approved by the board, and NRS 644-204 item 5C to state that the cosmetology hair designer test could be challenged.
As long as they have those hours. As long as they have their,
licensed Nevada barber.
within good standing with their current license.
Correct. Yes, in other words, it says this, it would read specifically, if the applicant is a barber registered pursuant to Chapter 643 of NRS, they may challenge the hair designer test by the board.
Without the 400 hours?
I'm going to let Mr. Lander, I'm going to let you work out that exact wording.
So without the 400 hours, they can challenge it?
As a hair designer.
As a hair designer, not a cosmetologist, Linda.
So they'd be doing just hair, no nails, no skin.
There's
And
more.
that's what they're doing now.
There's more hours in barbering than they are in a hair designer, so that's why they'd be able to challenge it.
Okay. I don't see any reason to change the law, sorry.
Okay,
Personal opinion.
so that's okay. So we have a 3-to-1 that says we should try changing the law. I mean, all this stuff is going to go in front of the legislators anyway, and they can say that this is ridiculous and toss it out, or not.
It needs to be clarified either way, though.
Correct.
Present is not, it's not congruent as it stands.
But everything ends up going before the board anyway.
Correct. Before the full board and then in front of the legislature as well, you see. So, I mean, there's multiple steps where this can be talked about and challenged and changed. But we're going to say that we want better clarification, and we want to say that this is more congruent with our current requirements for a hair designer to become a cosmetologist. They need 600 hours. And so that's more consistent. And that because they've already done 1,500 hours and have a current license, that consistently they have more hours than are required to be a hair designer, and thus they should be allowed to take the test. And so that's what we're trying to state with this. So,
And I agree. I think the reasoning behind it, which is what we're capturing today, is very important when we go to speak with the legislature, so that they know we're doing it for consistency, and we can show specifically how the hours match up, how they don't match up, and what we're requiring hair designers to do, which would be the equivalent of a barber, so that we're just trying to apply consistency throughout the law. That's something that I think I can speak with the legislators very easily about when we're talking about consistency.
Now, would this also cross over for out of state, or just in the state of Nevada?
Just in the state of Nevada, because it specifically says in here, the applicant is a barber registered pursuant to Chapter 643 of NRS. In other words, they have to be a Nevada licensed barber.
And I would say, I would definitely want to keep that wording in, because there's no way that we can coordinate with every board of barbering across the United States.
Because my concern is coming from another state with low barbering hours, and then coming into here, getting their license, the reciprocity on their license of barbering, which I don't know how they do that. That's obviously not our jurisdiction. But then getting that license and then getting that hair designer license, that would be a concern. Although, how do you end up monitoring that?
We have to trust in the barbering licensing board. And as far as if they come directly here from another state and apply for a cosmetology or hair designer license, they would still have to prove hours. And if we word this in such a way that it represents the hours, say a barber were to come in from another state and have 1,000 hours, we could then say, well, you need 200 hours to become a designer, because that's how it's consistent with our laws.
Well, I think with this, I think that it's mandatory that they have their barbering license first, that they would have to get the reciprocity from the barbering board, one board to another board, not the barbering board to the cosmetology board, but if they say they're in New Jersey, then they need to come to get the reciprocity from the barbering board here in Nevada, get get their approval, get licensed here, and then come to us and ask for that, to be able to challenge that. I think that they need to go through that barbering board first.
Perhaps. The question I have is, the way I understood Amy, is that if a barber comes in and applies, we give them hours according to their schooling. Is that correct? Do we apply that?
I'm not sure. They've had it once in 6 years, so
right.
I'm not sure if the people that process that are still on staff or not, but we can certainly check into it. It's a very rare occurrence.
Yeah. I mean, how many hair designers do we have right now?
Just fine.
Annie, are you talking? Annie has a comment.
Okay, are you talking about barbers coming to the cosmetology board? Is that what you were speaking on?
Not to the board, just to
In other words, the cosmetology board is licensed for license. You have to have, coming from another state, we honor the licenses that we have the categories in. If you're a cosmetologist coming from another state with hours, we take those hours, and you have to make up the difference. If you come with a current license from another state, then you can take the testing that we have and become licensed here, which is called reciprocity. We don't ever take barber hours, if that's what you're indicating.
So we will just be consistent with that. And
they have to go to the barber board.
Correct. And if they get a Nevada barber license, then we can, and they want to be a Cosmo, then we apply these laws that we're proposing, the changes for consistency. Okay, all right. So then we will do that. Moving on to display of license. Let's see, what was it? 360.
Display of license, okay.
So this is where we're looking at NRS 360, Section 2, Item A, reads, leasing space to or employing a barber. Such a barber remains under the jurisdiction of the State Barbers' Health and Sanitation Board and remains subject to the laws and regulations of this state applicable to his or her business or profession. So a lot of times we've been talking about leasing, so I'm really kind of wanting to clarify this employing a barber versus the leasing, because under leasing we clearly have other rules and regulations that say they have to have their own space. But where was I reading this here? Hang on.
Wouldn't somebody's business as an LLC be able to employ a barber and not under the jurisdiction of a cosmetological license?
Well, what I'm thinking here is when you lease a space, we have rules and regulations that say that they get their own space with
Right.
a lockable door, walls, and so on and so forth.
Right.
But if we employ somebody, that's not clear. If I take and hire someone and pay them a salary or commission or something like that, now they're under the jurisdiction of the State Barbers' Health and Sanitation Board, but it's not exactly clear that they need to have their own space because I'm employing them. And that means that they're in my business and they're not leasing a space from my business, because when I lease space, I no longer have control of what they do or don't do. But if I'm employing them, I control when they show up, when they go home, how much they do, what they do, and so on and so forth. So I'm a little concerned that we're not exactly clear enough under this section about employing a barber. Now I realize that in today's world of cosmetology, there's hardly anybody that's employing a barber, but in theory, say somebody like Supercuts or Great Clips or something who does employ a cosmetologist, they could employ a barber.
You can employ anybody you want,
And
can't you?
yes, they could employ a barber or a cosmetologist.
Or a
but we
psychic,
wouldn't
and you can
have
employ
to-
anybody you want in those places, can't you?
What's that? April?
Oh yeah, you can employ anybody you want in, I'm assuming.
You can employ anyone that you desire, and if you employ a barber, he still falls under the jurisdiction of his licensing board.
Yes,
That-
but
that's-
it doesn't necessarily
that's why he
mean
has the
that we don't
space
for-
that's designated
Space
for
includes
him.
without limitation a separate room, and if I'm leasing space, then I would fall under section 4B, but if I'm employing a barber, 4B doesn't apply to me.
Simply because you're employing him does not pull him back up under cosmetology. You may be employing him and then he falls under you as far as IRS concerned, but he wouldn't be under our jurisdiction.
Correct, but he could have a station out in the open and work side by side.
No, he wouldn't have a station. If you're leasing, he has to have a space separated.
No matter if you employ them or, doesn't matter, they still need that separate space.
It has to be separated.
Doesn't he have to put his own shampoo
Wait,
bowl also?
Yes,
He needs to have
everything has to be separate.
Then the law needs to be written differently.
The law needs to be written differently because currently, under 2A, it says leasing space. Space is defined further on in item 4B, but it does not clarify employment, and employment is very different from leasing. So I think this needs to be clarified.
Under NAC 644307 explains the leasing process.
I understand leasing We understand that leasing isn't the issue. Employment is the issue. In other words, I'm paying a guy an hourly wage or commission, and he's my employee. That is a very different scenario from someone who's leasing a space from me.
Well, and as an employer, I can tell you that if I have somebody behind a closed door, they're not part of my day-to-day systems or operations. I can't keep an eye on them. I can't motivate them. It completely changes everything. So if they're leasing, they can do whatever they want, come and go, do what they want, lay on the, whatever they want to do. But if you're employing somebody, it's different. They need to be part of your systems.
Correct. And it's odd that they are part of the jurisdiction of the state barber's health. In other words, they can have a dirty station and do stuff, and we walk in there and say, well, I'm a barber. And we can't cite them, and yet, according to this, they don't have to have that. According to the way I read this, it's they wouldn't need their own space if I'm employing them.
I think it'd be interesting to put in wording that would state, and then if they're going to be employed by a cosmetological establishment, that they would have to fall under their.
Well, I think we shouldn't employ a barber.
That's one way to go.
I think we can lease a space because currently that's just how it is. But I think that it's, I think we just shouldn't employ barbers because it's a conflict of interest. I'm employing someone that's outside of my jurisdiction, falls under a whole different set of rules. Now I would actually, as an employee, as an employer, probably need to have a barber's license because I'm employing. It's just to me not conducive to administrating sanitation health, because really, truthfully, a barber's board, if a barber doesn't understand, the barber's board, if they don't know that a barber is employed at that particular location, they'll never come and inspect them because they're not an establishment.
I think that's on an assumption.
Yeah, well, they're supposed to, we know that, but
I would never want somebody to tell me who I could hire and who I couldn't hire. That seems so, I don't know, I would.
We already do. We already tell you can only hire a licensed cosmetologist.
Yes, but I mean, if I could hire other people too, I could hire estheticians, I could hire nail techs, I could hire anybody under the scope to practice. I could hire all kinds of people.
But according to this, let me give you an example. Let me clarify this here, okay? It says here that also under item number 3, the operator of a cosmetological establishment may lease space at the cosmetological establishment to provide for health care, for the purpose of providing health care, provider of health care who leases, we have all these things for health care. And somewhere in here, we have these exemptions here. For instance, did you know that a chiropractor can do hair without any license of any kind? Just saying. Under these exemptions, if you read these exemptions, you just kind of go, really?
I think that having 2 different boards inspecting my salon is not a bad thing. I mean, I think it keeps everybody in line. If you have
I don't think that the barber board knows that that person's working because...
But how do you know that, though? You're assuming.
Because we inspect cosmetological establishments, and I'm sure that barbers inspect cosmetological establishments. I mean barber establishments.
Yeah, they expect everyone. They literally inspect 7 days. I was at that sunsetting committee, and 175 barbers showed up. You have what? How many people do we have showing up for cosmetology? It's a huge subculture, huge, and they are strict. I have seen that barber board perform. They do not mess around. They inspect 7 days a week. I don't know if you've ever been to a barber board meeting, but they don't mess around. They take it extremely seriously.
In the hotel, we have a barber shop, which is right across from me, where there's cosmetologists working. And we inspect the cosmetologists. And when they have, Annie's people come in, they inspect her room. But I've seen the barber shop, the barber board inspectors in there, and I mean, they're all over the place. They're stricter than we are.
They are. I highly recommend to go to a barber's board meeting sometime because it is really strict. There is no messing around, and it is filled with barbers who are participating and have a voice in their industry.
I believe if they had known this was coming up today, they would have probably been here.
Absolutely, without a doubt.
One thing I would like to say about the employment of barbers, you can't think of it from a cosmetologist's viewpoint, because we don't require cosmetologists to own the salon. So you could have an independent businessman who employs doctors for a medical spa with cosmetologists and barbers, put them all under the same roof, separate doors, separate locked areas for those services. But that is something that we allow today. The only thing I would be very cautious of is what April was talking about saying who you can and can't employ. You can say who falls under our jurisdiction, but the ability to employ a barber, I don't think you can restrict that from a salon owner. It doesn't have to be a cosmetologist, but a business person owns a salon. I'm not sure that you can restrict their ability to employ a barber. Would be my only caution.
So should we add the words and or? And or? Living persons who may be employed?
If we put the and/or, then I think the space requirement would be more applicable. Or we could argue that it would be.
I think we should leave it alone.
All right, so let's take a quick vote on should we leave it alone or change it or clarify it.
I motion to leave it alone.
I vote for clarifying.
I vote for clarifying.
April?
I vote for leaving it alone.
Linda?
I think we should leave it alone.
Gary?
By law, I don't have a vote.
This isn't a vote, this is an opinion.
Maybe this is something we should come back to and put on the back burner and readdress.
I have a question, Gary.
I think we make a decision.
Yeah, my opinion on this is prior to making any adjustments to the law, I would agree with April to attend a barber board meeting, and I would certainly do that. As a matter of fact, one of the things that I discussed in staff, management staff, was to have a meeting set up with the executive director of the barber board and get to know what they do, how they operate, because again, it's myth, rumors, whatever, what they do versus what we do, and try and get some clarification. We could definitely bring this back up at a meeting subsequent to my meeting with them, would probably be the best.
Gary, it would be nice to invite them to our meeting as well. I think extending a hand to just letting them know a heads up and on all our meetings wouldn't be a bad thing.
All right, so we're going to leave this alone because it's not that important and it doesn't happen that often. So let's just, we talked about it. We'll take a 5-minute break. Okay, 5-minute break. Be great.
Okay, thanks.
Being at 12:13. All right, so Jeanette left, and so now it's the three of us.
Hello.
All right, so next on the agenda, the item was, let's see, that was the display of licenses, the next thing.
That was the old leasing version.
That was the leasing thing. Okay, so that was that. Okay, we covered that. And then the next thing would be exemptions. Number 460. Barbers, insofar as their usual and ordinary vocation and profession is concerned, when engaged in any of the following practices: cleansing or singeing of the hair of any person, massaging, cleansing, stimulating. Okay, so the way I read this is that I could employ a barber to cleanse or singe the hair of any person, and they are exempt from cosmetological. So your fellow there that wants to have shampoo people, he needs to have them be barbers, right? Yeah, all right, so massaging, cleansing, stimulating, exercising, or similar work upon the scalp, face, or neck of a person with the hands or with a mechanical or electrical apparatus or appliances, or by the use of cosmetic preparations, antiseptics, tonics, lotions, or creams. So why are we exempting barbers? See, so what is this? Are we exempting them from being able to do this? Or are we exempted? The following persons are exempt from the provisions of this chapter. Barbers.
And what we're saying is that barbers are exempt from our regulation, that they're regulated by the barber board. And my assumption is that when they're describing subsection 1 and 2, that comes from their section that says specifically what barbers are authorized to do. So it specifically says you're a barber and you're doing these services. We do not inspect that station. We do not regulate those services.
Which would probably tie back into the employment factor up here. If they're employed and they're doing these things, they would be exempt. That gets really convoluted, doesn't it? I could say, since this doesn't come up very often, let's just bypass this, but that wouldn't be really the point of this. The point is to make sure that it's clear and that we know what we're doing and we know how to enforce those things. So I would guess that where this comes from is if I was leasing a space as a barber, I would rent out a room. That room may or may not have a shampoo bowl in it. And if I took my barber client into the salon and used the shampoo bowl to massage, cleanse, stimulate with hands or electrical or use of cosmetic preparation, antiseptics, lotions, or creams, in theory, I could do that. I'd be okay with that. Okay, so April, do you feel that this needs any kind of clarification or anything like that?
I'm still reading it here.
Okay.
No, I'm looking at this one too. No, the other one is about the reference runs.
What is your question, Perry? I'm a little confused.
Well, there isn't a question. It's a matter of looking this over and determining why it's here. Does it benefit us? Does it harm us? Is it unclear? Those kinds of things. That's all I'm trying to do is work out make sure that this is current in today's world and that this isn't an antiquated law. So all I'm asking is that we look this over and see if there's something that does it need to be here? Does it not need to be here? Should it be clarified in one way or another? That's all I'm looking at.
I think there's some under the retailers would. Definitely. I mean, I think salons now retail more.
Yeah, that's not what we're talking about. We're talking specifically about
the barbers?
Item C, 1 and 2. Barbers.
Sorry, I was looking at the whole thing.
I don't see anything wrong with it.
I don't either.
Actually, it's just saying they're
I
exempt.
don't see anything wrong with that either. I was looking at the whole NRS.
Yeah.
I think
this allows, what this would allow for is a barber to shampoo someone in a cosmetological establishment if their room didn't contain a shampoo bowl. And without this, it would not work. They wouldn't be able to do that. They couldn't rinse a color or a perm or do anything else in that area.
Would a salon be able to designate if they had multiple sinks, one sink that would be designated as the barber's sink?
That would be out of our jurisdiction. That's why it's an exemption. We have no say on that.
This exempts them completely and
They're
allows them
exempt.
to, yeah.
Yeah,
I
well, if
think-
it
I think
exempts, it exempts. I don't think there's anything wrong with exempting any of this.
Yeah, because if they don't exempt it, then there's a problem.
Right.
Then you have a barber who's working inside a cosmetological establishment.
Correct.
Who's shampooing somebody's hair. Right. So, okay. So
I think they need to be fully contained in that, when that door is shut, they need to be fully contained in there. That's their stuff, that's their, there's nothing else outside their stuff, except, I don't know, retail.
Yeah, but that's not how that is, and this allows for someone to have just a room and still have the barber be able to conduct business inside that space. I think that's okay. I'm pretty good with that. Anybody want to make any changes here, Linda, April?
No, I don't see anything.
No, I'm fine with it.
Moving on. Moving on then. Styling of hair pieces. Okay, styling of hair pieces. And this, number 3, 644.475, number 3, this section does not prohibit a licensed barber from performing any service with respect to hair pieces which a licensed cosmetologist or hair designer may perform. So any establishment in which the hair pieces are sold may set or style a new hairpiece on a person in preparation for retail sale. After the sale, the hairpiece may only be set or styled by a licensed cosmetologist or hair designer. A used hairpiece must be cleaned by a licensed cosmetologist or a hair designer before being sold or tried on a customer.
That seems a little bit antiquated. I mean, now they just have little wig caps disposable wig caps that they put on and try on. They don't even, you don't need to clean them anymore. They have those pre-sanitized wig caps that a lot of places, if you're going out to try a bunch of wigs on, that you purchase for $1 or 50 cents, or they give you to try them on. So that may be something that you can.
If I own a wig and I bring it to a salon, but this is basically saying that I own a wig, I'm going to bring it to you and you're going to clean and set and style my wig for me. It says that a barber that you may have in your salon could clean and set those hair pieces, which is good because a lot of that stuff would be men's hair pieces and things of that nature. And yeah, I don't see anything wrong with this whatsoever. April, Linda, any comments?
No, I don't see anything wrong with it either.
No, I'm fine with it.
I am too. Okay, we'll leave it alone. Moving on. That concludes review of number 6. We've done number 7. Moving on to number 8. Review and possibly formulate revisions for submission to 2015 legislature NRS 644-375 and 644-3777 food and beverage sales. An issue that comes up frequently is the ability of licensees to offer alcoholic beverages to clients and also the ability of the licensee to partake of alcohol while working. We currently have no laws or regulations prohibiting either, and there is a need to clarify this. Other laws that may need clarification is NRS 644-430, grounds authorized disciplinary actions, orders imposing discipline deemed public records. All right, so for me, I have personal experience with this. And what happens here is you get the State Board of Taxation that walks in your door and says to you, I'm here to inspect and see if you have any alcohol on the premises. And then they come to you and they say, if you had alcohol on the premises, you need to pay that tax because you didn't buy it from your local alcohol distributor. Right. Yeah, I thought this was rather interesting. They hated me after a little while because I didn't have alcohol on that day, and they couldn't. I didn't have anything, and they didn't have a judgment that I had to argue. I just argued for argument's sake on this, because we know that within our industry we have quite a few people who believe that a glass of wine should be shared with your pedicure or your manicure or your hair service, and it's quite common in our industry to see that. And when I fought, the argument for the State Board of Taxation was that they will allow a bar to purchase a bottle of alcohol at, say, Costco, but they must then serve that alcohol free of charge. Because if they charge for it, then that violates the laws because they have to purchase it from a distributor who has a higher tax rate, and we get different taxes from them than we do if we bought the alcohol from, say, CVS or something like that. So the question is, do we feel that we need to be involved in regulating this at all? Clearly we say we can't be drunk. That's part of our regulations, right? I would like to know from the inspectors, from Annie, have you or do you frequently encounter someone who is serving and or is intoxicated during your inspections?
I want to know too, Annie.
During my tenure here, we've never encountered someone that was drunk. And if so, we wouldn't have known, we wouldn't have had any means to determine that.
Correct, because we can't administer a breathalyzer, for instance, that says, oh, you're over 0.0 H, you can't do hair. All right.
Oh, there are so many, though. There are just so many.
So many.
Which is so scary. And I tell them, like, you need to go home.
Yes. But it does happen. In my opinion
This is Annie.
to me, this is consumer regulated, okay? In other words, if my client brings me a beer and I'm cutting their hair and sharing a beer with my client obviously thinks that that's a good thing. And there's no charge for it, so we're not charging, so therefore there's nothing that I think is going wrong with that. If a client feels that I'm overindulging in alcohol, they can choose to not come and see me. Or they can file a complaint against me because I somehow did something in a negligent way, which gives them the right to sue me and or bring a complaint against me. So I think that this is pretty self-regulating, and I think we should just leave it alone as we currently do.
Yeah, how does that work if the alcohol was a gift? If somebody brings in, oh, I brought you a bottle of champagne. I mean, isn't that different from somebody?
That does not mean that you need to drink it.
Right.
You can take it home.
So if the Department of Taxation came in, Perry, and says, well, this was a gift, it wasn't my purchase.
Yeah, it's exempted as a gift. Yeah, it's
like the marijuana laws in California. If it was a gift, then you're exempt.
By the way, I have it on good authority that the Department of Taxation no longer inspects salons. This was a bright idea that they had about a year ago. And they walked into my salon, and heaven help it when somebody comes in and slaps a badge on my front counter and says, I'm here to inspect you.
I don't want to be there that day.
Yeah, it was about an interesting day. But
I have nothing on this, so.
Yeah, I think we should just leave it alone. I mean,
Leave it alone.
It's an issue, being it hasn't been an issue in the past, and I think it's kind of like, if
Let's not put a magnifying glass on it.
Well, a lot of salons also have the machines too that, for drinks and snacks, so they're paying sales tax on that, which doesn't have anything to do with us either, so I don't have a problem with this.
And I think that if somebody serves alcohol for pay, in other words, we charge, I think then they need a liquor license, and that comes under a completely different jurisdiction than we have, and so then that's a whole different regulation. It's something that we just leave alone. Any objection to leaving this alone?
No objection.
I'm fine.
Okay, we leave it alone?
Do we need to move to leave it alone? Do we need to vote on to leave it alone? Not really.
No, we're discussing. This committee is a little different than the board meetings, because what we're doing is discussing and presenting for future recommendations. And
I just wasn't sure if this one was. Okay, so this isn't for possible action, okay.
Yeah, for possible action, we're going to just simply by discussion, have the general consensus that we move on and no action needed on this particular item.
Okay.
Okay, all right, number 9, comments by general public?
No general public here.
He's good, all right.
Hello,
Number 10?
could we go back to the clarification on the manicuring? I was a little
Yes.
confused there. Actually, when you read the law as you wished it to become, you were leaving out the part of the law that allowed the manicurist to be in the salon. That's the only place that it appears. I was a little mixed up with the Attorney General's opinion. I was thinking of where the manicurist, the opinion where the manicurist cannot practice podiatry, which is called chiropody. But the law, if you take that out of the law, then they would no longer be able to work in, the manicurist would not be able to work in the barbershop. And that's the only place that it
They
appears.
could lease a station from, I don't know what their laws are. If they want manicurists to be in there, they would have to create laws that allow that to occur. But as far as we're concerned, they would be operating outside of a cosmetological establishment.
Oh, no, but that law allows them to do that, according to that law. I don't know, it was done sometime during one of the legislative processes.
Let's do it.
That's an actual law.
Thank you. What I think we'll do is staff will take what we have done today and present us a summary of that, just like they did during the last meeting. And our first agenda item will be to review those changes that we think we made, just so that we can see them all in one lump sum. And at that point in time, if there's anything that conflicts, or if they determine that the changes that we have talked about really, under further scrutiny, don't work, that they would bring that and reopen that up so that we could rediscuss those items that, under further scrutiny, don't work.
We'll do that. The other thing that I'm going to do is attempt to have a meeting with the barber board prior to the next meeting, to the next law subcommittee meeting, so we can we can discuss what their opinions were and all, and I'll invite them to come to the next meeting. So
That would be good. I'd like to have that, yeah.
so we can have a good discussion between the two boards.
In particular, this manicuring thing is kind of interesting to me, and I'd like to know whether or not they hire manicurists. How often is there a manicurist in a barber? Is this kind of a moot subject? I mean, I don't know. So. Okay, can I get a motion to adjourn?
I'll motion to adjourn.
I second.
All right. All in favor? Aye.
Aye.
Good. Meeting adjourned.
Thank you, Perry.
Thanks very much.